All right, good morning, everyone. Apologies for the delayed start. I will bring the justices in now. All right, good morning again, everyone. This is the Court of Appeal for Bermuda sitting on its second day for the St. John's Trust Company Limited against Medlands PTC Limited et al. The proceedings again are taken before my Lord Justice Anthony Smelly presiding and Justices Gloucester and Simmons. The appearances are as before. But before we start, I do not seem to see Justice Simmons. So let me just see if she made it out of the breakout room. Yeah, she has now. All right, my Lord Smelly.
Morning, everyone. As a first order of business, I must inquire whether you have all seen an email from Mr. Marshall
I certainly have, my lord.
inviting the court to inquire as to the manner of funding of the appeal. And we do invite Mr. Cumming to address that issue.
I'm very grateful, my lord. I was planning on doing it anyway, and if Mr. Machel had contacted me overnight, I'd have let him know the answer, because we've been in no way coy about it. SJTC is funding its involvement in these proceedings and other legal proceedings it's involved in from its own funds. It has taken loans, and those loans are connected to Cabarita, which is its shareholder, and of course, Mr. Tameen is director of Cabarita, and we make and have made no secret of that. And indeed, I understood some of the questions I'd fielded yesterday to be premised on similar assumptions.
Could I ask this question, please, Mr. President?
Yes, please.
Without the assistance of the loans, would the St. John's be able to fund this litigation and the other litigation in which it's involved?
I would have to take further instructions, I'm afraid, in order to answer that. I'm very content to do so and to confirm the answer in writing if it's most effective, or orally if it's I'm still on my feet, to the court as soon as possible. And I'm sure that those instructing me on who are in attendance can begin to investigate that and get an answer to me as swiftly as possible.
Thank you very much.
I should say I give that answer in no way to duck your ladyship's question, but just to make sure that any answer I give is absolutely accurate.
Is it the expectation that St. John will be refunded from the trust in any way?
I certainly do not believe it is the expectation that it will be refunded in respect of everything from the trust. In order to know exactly what aspirations or hopes there may be, again, I would have to take further instructions. But for example, costs of the corporate proceedings may well be, and I've got to be frank, no consideration to this at all and don't have instructions, may well not be appropriate costs to recover from the trust if it was to be trustee. I certainly am aware of no intention whatsoever, if the orders were to be set aside, an SJTC were pro tem to become trustee again while things are sorted out at first instance. I have got no expectation that what's going to happen is Mr. Watlington and Mr. Ferguson are suddenly going to go, good, SJTC is the trustee, let's make ourselves whole from trust funds. But again, I don't have proper instructions on that. I don't think at this point I can say more than that, but I can take instructions.
Yes, will you please?
I will, yes.
Right, well, you'll continue, please, Mr. Cumming.
I'm grateful, my lord and my ladies. Two housekeeping matters, if I can call them that, at the outset. First of all, chronology. There have been quite extensive efforts overnight to agree a chronology. A real degree of progress has been made, but there have been some further comments that were given about an hour before this hearing began. And so we're not quite at the point of agreement yet, but I am hopeful, having certainly glanced over the latest exchanges, that we will be able to provide an agreed chronology to the court as swiftly as possible. The second point of housekeeping is just to update the court on timings. I'm conscious that we're over a quarter of an hour into my time this morning already, but I was aiming, and I'm still aiming, to be finished by lunchtime if I possibly can be. I understand from emails exchanged between all counsel that take a contentious position on this appeal that Mr. Brownbill anticipates being no more than an hour and a half, and I think he said he's going to do his best to be a lot less than that. And then I believe that Mr. Machel, Mr. Tregear and Mr. Ham are going to divide up all the remaining time until the last hour and a half tomorrow, if indeed we get to the end of tomorrow, when there will be time for a short reply. And for my part, I'm happy to squeeze that as appropriate if that proves necessary, because we end up taking slightly more time than we expect. I just mentioned that so that the court's appraised of where discussions amongst counsel have reached.
I see.
Turning then to my substantive submissions, last night I was addressing the reasons why SJTC contends it would be inappropriate to appoint BCT Limited as trustee at this hearing, and I emphasise that. And I just really want to wrap that up this morning. The next point I wanted to make was to run through the chronology of BCT Limited's emergence in a little more detail than I did yesterday. The first hint that those who are now seeking BCT's appointment wish there to be a new institutional trustee in the longer term was, I believe, in Mr. Lang's submissions opposing SJTC's application to enlarge time for this appeal, dated the 18th of August last year. And just for your lordship and your ladyship's notes, the bundle reference is bundle 4, tab 28, page 2560. That was 4.5 months before Mrs. Brockman made her application on New Year's Eve at the very end of last year. There was a hiatus, so far at least as SJTC could tell, between that indication in a footnote of Mr. Lang's submissions in August and the hearing before the Chief Justice on the 2nd of November. And your lordship and your ladyships will recall we looked at that yesterday when Mr. Malik suggested that a trustee regulated by the Bermuda Monetary Authority was under consideration and an application might be made in just a few weeks. I note that the letter informing Medlands of that from Cox Hallett Wilkinson, who were acting, I believe it was Cox Hallett Wilkinson, who were acting at that time for both Mr. and Mrs. Brockman, was sent on the very morning of the first day of that appeal before the Chief Justice. The same day that was revealed, those instructing me wrote to each of Cox Hallett Wilkinson, for who they termed the Brockman beneficiaries, and we looked at this letter yesterday as well, and to Medlands and to Mr. Lang, wanting to know who the trustee might be for perfectly good and proper reasons. They subsequently chased that letter and they were ignored. It was never answered. In the meantime, Mrs. Brockman, SJTC learned that Mrs. Brockman had ceased to instruct Cox Hallett Wilkinson together with Mr. Brockman, instead instructing her own firm. That doesn't need to be explained, but it's, I think Mr. Tregear might not be on mute. And I just mention that so that he's aware. It's fairly hard to understand why Mrs. Brockman moved from Cox-Hallock Wilkinson when barely a month later, Mr. Brockman was sending a memo to his wife asking her to represent his interests in Mrs. Brockman's new proceedings. In any event, on the 1st of December, so basically a month later, Medlands writes to Mrs. Brockman's recently instructed new firm of Bermudian attorneys, Hurrian, and we can see that letter in bundle 9 at tab 78, page 5785. Bundle 9, tab 78, page 5785. It's in reply to the letter from Marshall, Deal and Myers, who instruct me on behalf of St. John's, SJTC, which are on that letter's on the previous 2 pages. And they'd asked, and you'll see on the penultimate paragraph of 5783, please inform us as a matter of urgency, in any event before 4:30 on the 3rd of November, of any intention to seek to appoint a new trustee and the identity of any new trustee that is or has been under consideration, so we can inform the CJ. The only thing that's addressed that letter is this letter from Conyers on 5785, dated the 1st of December. We've reviewed the correspondence from St. John's, SJTC, asking whether the US DOJ has been informed of the plans of the human beneficiaries of the B Trust to apply to replace Medlands with a different trustee. Medlands lawyers have discussed the B Trust with the DOJ on many occasions. We can confirm the following. On the 20th of August, the DOJ was informed of the likelihood of an application by the human beneficiaries to the Bermuda court to replace Medlands with an institutional trustee. That's 2 days after Mr. Lang's submissions opposing an enlargement of time. And then on the 3rd of November 2020, so that's the very day after we had written on the evening of the 2nd, saying, can you please tell us, and this is the tail end of the letter on 5784, you may recall, what's been said to the Attorney General and the DOJ about this. On the very next day, Medlands decided to update the DOJ that there was a real likelihood the human beneficiaries would be applying in the near future for a court order to replace Medlands with an institutional trustee. We haven't seen that, any correspondence in relation to that. And B, the name of the professional services group, which would likely be the replacement institutional trustee. So everyone was, this was copied to those instructing me, but there was, as will be seen, a fair degree of coyness. I can't understand why, but there it is. Then it continues, next page, we hope this is helpful to the beneficiaries. We're copying this to MDM's counsel for SJTC. Why all of a sudden was that letter sent on the 1st of December? Well, we might perhaps see the answer in this same bundle at page 5765. It's a letter sent the next day from Medlands to Mr. Lang. The 3rd paragraph in the body of the letter, we hereby give you 90 days written notice of our resignation to be effective on or before the 2nd of March. We note we'll remain trustee of the trust until such time as a replacement trustee is appointed, even if this is after the 2nd of March. And that makes good the submission I made to you, my lord, yesterday, when you asked me what would happen if things drifted past the 2nd of March and the orders were still in place. Then SJTC wrote in my submission very sensibly on the 23rd of December, trying to avoid this hearing. And that letter is on tab 74, page 5596 of this same bundle. The first page isn't terribly helpful because you'll just see effectively it's sent to everybody, including, I note, the Attorney General. Of course, what discussions had taken place with the Attorney General wasn't revealed in response to MDM's letter of the 2nd of November. You'll see from the top of 5596, dated the 23rd of December, the meat of the letters over the page. The 3rd paragraph on page 5597 says, further, we note Mr. Lang's respondent's notice argues in effect for a rehearing by the Court of Appeal. That argument is, and I read this with a degree of reticence, that argument's doomed to fail in front of the Court of Appeal, but plainly there will be issues for determination at first instance following the orders being set aside. They should be dealt with by a judge in possession of all potentially relevant material and all potentially relevant representations and evidence on that material, which will obviously not be before the Court of Appeal. Please therefore confirm by the 4th of January that your client will agree to the orders being set aside so the parties can proceed to have the summonses on which they were made remitted to the Chief Justice, who, as well as being Chief Justice, is, it's noted, already familiar with the matter, and unlike Mrs. Justice Subert-Williams, is not disabled from determining the issues of substance by reason of having acted as a Bedo judge, to decide, based on proper representations and submissions, on the basis that the appellant, as trustee or trustee dissenter, will be a party to those summonses and entitled to be represented and make submissions. This would be a far more reasonable approach than the 9 respondents' proposed application seeking the appointment of a new trustee, the outcome of which our client will be entitled to set aside in the event our client succeeds on its appeal. If you agree, we'd intend to file an application for determination of those issues. And that's a sign in my submission of good faith in trying to get this on at first instance as swiftly as possible, on or before the 8th of January, if that's agreed to by the 4th of January. So the end of the first week back in this new year. I'd like to show you the replies to that letter, but there aren't any. What happens is on the 31st of December, just 11 days before the deadline for skeleton arguments, and barely 3 weeks before the appeal, Mrs. Brockman begins her new proceedings. And strikingly doesn't apply formally in these proceedings on the 31st of December for the relief which she's seeking in those other proceedings. Now, my submission is, it is hard to avoid the conclusion that this is carefully choreographed, not to ensure a proper and timely judicial consideration of the issues, but instead to try to avoid that. In any event, what's happened, and that chronology, is not in my submission redolent of a crushing need for a new trustee to be appointed today, rather than in some weeks' time after full and proper consideration could have been given with all the proper evidence and material before the court. So that's the conclusion of my submissions as to why in any event, your lordship and your ladyship should not be appointing BCT Limited at this hearing.
What evidence are you referring to, Mr. Cumming?
Well, so
you said the proper evidence before the court.
Various things. Firstly, it is evidence from Mr. Watlington and Mr. Ferguson as to historic matters that it ought to be appropriate to take into consideration, which is not clearly presented before this court.
What sort of historic matters? What are we, in order to decide whether to appoint a new trustee, what historic matters are you referring to that we need to be informed about?
Certain of the issues that have been articulated already during the course of this hearing, but the real meat and what I was coming on to say is documents that are, for example, amongst the 40,000 that I showed your ladyship yesterday existed, that may have a bearing on it, that ought to be searched for relevant material in light of
what issue? Going to what issue?
The appointment of potentially BCT Limited as trustee.
The allegation being?
I'm not making an allegation. The court ought to be satisfied that BCT Limited and its directors are appropriate for appointment. A trustee coming before a court when there is a proposal to appoint a new trustee needs to give full and frank disclosure of the position. Today, and this is more evidence that's required, we have no evidence from the trustee as to the current position regarding the trust. As I was running through yesterday evening, there are these vague, sweeping suggestions made by Mrs. Brockman in her affidavit, not backed up with detail at all, but the position is not set out by the trustee, by Medlands. There's nothing. So my submission there is the court just doesn't know in a meaningful, real sense what the demands of being trustee of this trust actually are.
So are you saying there's a need for evidence from Medlands in relation to the practical obligations on trustees?
Yes, and the recent history, which is said to mean that there needs to be an appointment of somebody now in order to manage the trust in the future.
Well, are you saying that I'm still not clear. Are you saying that St. John's should be replaced, should replace Medlands when it resigns as trustee?
I highly
Not clear
doubt.
what you're saying here.
Well, I'm saying, let me address the point that you've just made, but let me make sure I've answered your previous question, if I may. I am saying, and this is, I think, what you asked me, that the trustee needs to put evidence before the court of just what administration of the trust on a day-to-day basis at the moment involves. So I am saying that. Am I saying that at that next hearing, SJTC will say, don't appoint BCT, don't appoint any new trustee, there shouldn't even be a search for a new trustee, SJTC should be the trustee for as long as the court can possibly imagine? No, I'm not saying that.
So what are you saying in relation to St. John's?
Well, two things. Firstly, I'm saying that it's overwhelmingly likely that what St. John's will say at that hearing is either we've seen all the evidence, there've been exchanges of evidence, we've reviewed all the material we've got, and we think, having done that process for our part, that BCT is appropriate. We raised various concerns before the Court of Appeal. Those concerns, A, B, and C, have been met for reasons X, Y, and Z. So that's the first thing. The second thing, if that's not what they say, is I anticipate they'll be saying there should be a proper search that takes place if one hasn't happened. And I don't positively allege that it hasn't, but that needs to be scrutinised. There should be a proper search for an institutional trustee in Bermuda, if at all possible.
The reality is this concern, Mr. Cummins, is why should we proceed on the basis that there hasn't been that sort of due diligence carried out?
Because in my respectful submission, my lord, firstly, there's absolutely no evidence as to what search has been carried out. The search,
why should there be?
Because what's happening is Mrs. Brockman is coming to the court saying this person is an appropriate person to appoint as trustee of this trust, which exists in very, very vexed, contentious circumstances. And what's not being said is an individual with a power themselves is going to appoint the trustee. What's being said is you, the court, should endorse this appointment. That is a, with respect, very serious, very solemn matter.
Well, would you object to the matter being referred back to the Supreme Court for just that inquiry?
Well, that's exactly what we advocated on the 23rd of December, and it is what I'm advocating now. That is exactly what I'm seeking, my lord. That there should be a hearing.
That certainly wouldn't involve SJTC being contemplated as even as an interim appointee.
Well, the difficulty there, my lord.
What would be your standing before the court for these purposes?
The difficulty there,
you still be a stranger to the trust.
Well, I don't accept that we are a stranger to the trust, my lord. And there's two important.
So implicitly, what you'll be asking for, it seems, is a recognition that SJTC still continues. Otherwise, what would be your standing?
Well, I need to tackle the question you've asked directly. Your question is premised on the November and the December orders remaining in place. My submission is that they should not remain in place. If they are set aside, then what will happen is the position immediately prior to those orders will pertain again. Now, it is true that there is uncertainty as to quite what that position is. Potentially, HSBC will be the de jure trustee again. Potentially, SJTC will be the de jure trustee again. If SJTC isn't de jure trustee, it will be trustee de son tour. And Medlands will continue to hold as nominee such assets, and I will come on to this, as Medlands presently holds as trustee under those orders. So I accept that if the orders are maintained, and I'm hoping to come on as swiftly as possible this morning to that, and that's not an attempt not to tackle this question as exhaustively as possible. I'm very keen to. But if the orders are maintained, then SJTC will not be trustee. In my submission, SJTC will not be a stranger to the trust. It's a tagline. I'm not actually sure what it really means in substance, but it's a tagline that's thrown around a lot. SJTC will still be a former trustee. So it retains an interest in connection with the trust. And if the orders are upheld, it will still be entitled to the indemnity contained in the December order. That entitles it to be heard in relation to matters of trust administration, such as who the new trustee will be, because it has an interest, and that interest will be weighted accordingly by the court, but it has an interest in who the trustee is, because it will wish to see the trust assets safeguarded, so that indemnity is worth more than the paper it's written on. And there's an analogy there, of course.
Strikes me as a rather novel proposition that the beneficiary of an indemnity should have a right to say who the trustee should be in order to be able to be assured that his indemnity is secure.
I wouldn't put it
that right. Indemnity is as against the trust assets.
Exactly, my lord.
Okay. I've noted your submission.
Well, I wouldn't say that it has a right to say what the trustee is. I simply say that it has a right to be heard. And to put it another way, what could the possible proper objection be to it being heard? As I acknowledged a moment ago, due weight will be given, no doubt, to its submissions. But where the court's being asked to decide for itself what should happen in relation to the administration of this trust, the court's endorsement is being sought of the next steps, then it is proper, in my respectful submission, that all submissions from anybody potentially interested ought to be heard. And the position is, to draw an analogy with the point I was making yesterday about potential creditors of the trust. You'll recall Mr. Justice Sale's decision in Nat West at first instance, where he says creditors need to be treated fairly. Well, SJTC will be more than a mere creditor in that position, because it has its indemnity, and strictly speaking, its indemnity bites first on the assets before any interest of the beneficiaries, which is why any trustee is entitled to reimbursement under its indemnity before assets are distributed. It's why when new trustees are appointed, sometimes there is the argument, which your lordship will be very familiar with, about what assets should be retained by the old trustee against potential liabilities they've incurred whilst trustee. But so that's all why I say, even if the orders are upheld, there should not be an order appointing. Sorry, no, I haven't finished answering my lady Justice Gloucester's question about further evidence that will be before the court, and I must. Much of the material that ought to be before the court may be, but we obviously haven't had time to work through it yet, and this is the very point, may be in the material that was provided by Conyers only last Wednesday, and further material, which I was reminded overnight, was provided by Mr. Gilbert. This is all pursuant to the Chief Justice's order in his 14th of December decision on consequential matters arising from the corporate proceedings. And I'll deal with the chronology of that in a moment. But Mr. Gilbert, former director of SJTC and of Medlands, provided substantial further material late on Friday afternoon. And again, it is very well, it may well be that there is material there which the court, being asked to endorse the route that's now being proposed, ought properly to have regard to. And I touched on already the 40,000 plus documents provided by Mr. Tameen, which haven't been reviewed in light of what we now know was presented to Mrs. Justice Subert Williams at the November and December hearings last year. But the weight of that point is much weaker in the event that this court determines effectively to remake the orders that are contained in the November and December orders. In the event that the November and December orders are set aside, then the position as regards the appointment of BCT Limited, and I understand this may make it less attractive to your lordship and your ladyships to set aside the November and December orders, but my submission is that that must happen, and I will come on to that. Then the position in respect of appointing BCT becomes jurisprudentially more complicated. And that is because the court must proceed on the premise that it is removing either HSBC or SJTC as de jure trustee. And that is because at the time of the December order, one of them was de jure trustee. And if the December order is set aside, they will have remained de jure trustee. Now, any removal of a trustee in circumstances such as this should be begun by writ. And for that, I draw on an extract from Lewin in Authorities Bundle 3.
Are you really taking that technical point at this stage of the proceedings, Mr. Cumming?
Well, I don't accept it is a technical point, my lady. I was going to start with the technical point and explain its substantive significance. But if I could just show you this, and I will do it briskly. Authorities Bundle 3, tab 108. Joint Authorities Volume 3, tab 108. And your Lordship and your Ladyships will see paragraph 14080 on page 2397. Proceedings for the removal of a trustee under the inherent jurisdiction should be commenced by claim form under Part 7 of the English CPR, unless there's unlikely to be a substantial dispute of fact, and that's certainly not the case here, in which
Just
case...
a moment, I'm not quite with you as yet.
Sorry.
What page did you say?
Joint Authorities Volume 3, tab 108, and page 2397. It's an extract from Lewin on Trusts.
And that's paragraph 14081.
Correct, my lord. 080, right at the top of the page.
Right.
Formal proceeding. Now, the reasoning behind that applies similarly in Bermuda to a writ under Order 6. Moreover, and this is where we drift into the point of substance, which is why I'm going to this, at tab 109 of this bundle, page 2399, and I'm sorry it's all different tabs and not in a continuous run. 1483, circumstances not justifying removal. Then I'd ask your Lordship and your Ladyships to read all of 14084, and it continues to where it finishes on page 2400. And I emphasize that final passage. Any trustee may consider that duty requires a continuation in office where the troubles affecting the trust arise primarily from disagreements or hostilities between beneficiaries. Now here, the tension between Mr. and Mrs. Brockman on the one hand and the DOJ with its own interest or potential interest is, in my respectful submission, analogous to this, as is the potential tension between Mrs. Brockman and the interests of charity. Now, I don't use this as a justification for SJTC clinging to office forever, far from it, but I do say it's entirely proper for them to want to check that whoever takes over the stewardship of the trust is appropriate. Mr. Justice Park observed in Isaac and Isaac number 2, which I'm afraid isn't in the bundles, but I don't think this is controversial in truth, that removing trustees is, quote, a drastic step, unquote, and should only be done in, quote, a clear case, unquote. It is not enough to make a bald allegation that might, if proven, justify removing a trustee. And that is precisely why, for reasons, good reasons of substance, it is required that applications to remove a trustee are begun by writ, where there is any dispute of fact, so that those facts can be properly determined. And when the court is being asked to give its approval to either removal or appointment, the court is proceeding on the proper factual basis. And there's lots of support in the authorities for this. Supplemental authorities bundle, please. The supplemental authorities bundle. At tab 7 is the case of Forster and Davies, English Court of Appeal case. And I'd ask your lordship and your ladyships to turn to page 132 of the bundle, please. 132.
Page 132.
Exactly. Sorry, my lord. So the decision of Lord Justice Turner, 13 lines from the bottom of page 132, he begins just on the right-hand side. I certainly cannot agree with the argument at the bar that the mere fact of there being a dissension between one of the several Satiki Trust, the beneficiaries, and the trustee is a sufficient ground for this court removing that trustee from the trust. Because the consequence of that would be that one Satiki Trust might at any time raise a quarrel with the trustee and thereupon come to this court to discharge the trustee and remove him from the trust on the ground of the impossibility of their acting together. It would be the duty of the court, as I conceive in all cases of that description, to inquire and ascertain from whose fault that dissension or that cessation of friendly intercourse has arisen. The next relevant authority is at tab 4 of this bundle, page 93. It's the decision of In re Coombs, again an English Court of Appeal case. And your lordships will see from the left-hand column on page 93, just after the italics in the headnote end, this was a petition by some of the Satiki Trust under the will of one Coombs for the appointment of a new trustee in the place of one of the trustees thereof on the ground that he was of unsound mind. And what happened was he turned up and said, no, I'm not of unsound mind. At the very foot of that column, about 6 or 7 lines up, Lord Justice Cotton asks during argument, you're asking us to remove the trustee against his will on petition. Suppose you had some evidence the trustee was dishonest. Could the court try that issue on a petition? The implied answer being no, and therefore it's extended from that. The dispute over the soundness of mind of the trustee also can't properly be determined on a petition rather than for present purposes by a writ. And then Lord Justice Cotton's decision is in the right-hand column, just down from the top. This is a petition of a somewhat unusual character. It's presented under the Trustee Act of 1850 as amended, which gave a statutory power to appoint new trustees, and prays for the appointment of a new trustee on the ground one of the present trustees is of unsound mind. But so far from that being unopposed, that gentleman appears here and contends there's no ground for removing him and that he's not of unsound mind. Then 4 lines down, of course, if these petitioners are in a position to present a petition for inquiry into the state of mind of the trustee, they can do so. And if they wish to get an order declaring him to be a lunatic in the ordinary way, they may, if they desire it, bring an action in the High Court, relying in that action on any grounds, that's an action in the High Court, in that action on any grounds that may be sufficient for inducing the court to make an order removing him. Whether his incapacity arises from unsoundness of mind or any act of willful misconduct. Then after the next sentence, in my opinion, that's wrong. I do not go into the question as to whether there's jurisdiction under this act to do so or not, but it's been the constant course of practice since this act came into operation to decline to decide litigiously against a trustee whose removal is sought that he ought to be removed from his office of trustee. And then 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines on, if it could be done on the ground he was of unsound mind, it might be done as a matter of principle on any other ground that would justify the court in ordering his removal in an action, i.e. a writ for our purposes. An action can be brought in the High Court, and that's done at the ordinary peril. The next authority is Harrison and Mills, an Australian authority, at tab 10 of this bundle. And it's the judgment of Mr. Justice Needham in, I think, New South Wales. Yes, it is New South Wales. And I wanted to take your lordship and your ladyships to page 262 of the authorities bundle, 262, and to pick up Mr. Justice Needham's judgment just below letter B on the right-hand side. He sets out there the opinion, advice and directions that were sought on a number of questions, lettered from A to M inclusive. And I'll let your lordship and your ladyships just read that. Well, that's all relatively uncontroversial. That is something suitable for more administrative style proceedings. Then he goes on, the remaining questions are a somewhat different kind. Questions E to G inclusive ask for advice on the construction of the documents on matters which appear to be in controversy between the plaintiff and the other trustees. Well, there's echoes there of the points I was making yesterday. Question H asks whether some of the income is not held upon trust for the estate of the settlor. Question I asks whether any of the trustees, and if so, which, should be removed from the trust. Then the next paragraph, I've heard argument from counsel. Next paragraph, the plaintiff submits, the questions arise as section 63(1), again, the equivalent legislative provision in Australia, with respect to the management or administration of the trust property, or respect, no, I'm sorry, it's not the equivalent provision at all. That's a provision of the Trustee Act, which allows a trustee to seek advice from the court. And what the court's saying here, in effect, is that removal of trustees and the other contentious matters are not advice from the court. They're affecting real rights, and so need a different approach. And then 7 lines from the bottom, you see the answer. The other questions set out to which I've made reference is including the removal of the trustee, seek to determine matters in controversy between the parties, and possibly between the parties on one hand and the beneficiaries on the other. It's clear enough from the statement of facts itself, the plaintiff has basic and fundamental differences with the defendants on the execution of the trusts of the deed to which I've referred. The reference to the possibility that some trustees should be removed from the trust and the possibility of the plaintiff being entitled to an injunction against the defendants indicates the scope of the differences and the importance of the issues which could arise. I do not think it's a function of the court sitting to hear a summons under section 63, that's seeking advice, to determine matters of such basic controversy between trustees. What is required, and this is now me speaking, what is required is for matters to be properly set out and properly determined where the court's imprimatur is being sought on matters of substance that affect the constitution of the trust. Interestingly, there is an echo of this in the opinion principally drafted or principally signed by Mr. Hagen that was relied on, but not it appears, read to Mrs. Justice Sue Bear-Williams at the November and December hearings. I can go to it if it's necessary, but I don't think it is.
Can I be clear, please, Mr. Cumming? Was this point taken below?
No.
Well, shouldn't it have been?
Yes. Why wasn't it taken below? Because SJTC wasn't allowed to appear because Mr. Gilbert took it upon himself, wrongly, as an abusive process, to turn up at the court and say, oh, just appoint Medlands, of which I am sole director and sole shareholder.
And that's at the heart of the matter, isn't it? Because what we have here, at least ostensibly, is an application by the trustee itself for its removal, having regard to matters of fact which were incontrovertible. Conflict of interest.
There's 2 points on that, my lord. The first is there was not an application by the trustee. There was an application.
Well, that's your position.
Well, it is my position. It's also the decision of the Chief Justice.
Well, the Chief Justice, as I understand his ruling, said that the injunction which had restrained Mr. Watlington and Mr. Ferguson ought not to have been made, and so he discharged it.
Yes.
It was during the pendency of that very injunction that Mr. Gilbert, as then the sole authorized director, made this application to the court.
He was not the sole authorized
director. This whole argument about the need for a writ seems to me is rather odious in circumstances where the application was at least ostensibly made by the trustee itself.
It was ostensibly made, but the very important point is it was not made by the trustee itself.
Well, that's a different thing.
Well,
in my respect, that's wrong. It seems to me that taking us into this excursus on the need for a writ is really not very useful application of the time available.
Well, in my respectful submission, my lord, it is important because what I need to do is, in the event that we are successful on the appeal, I need to explain the difficulties in the court making an order properly appointing BCT Limited. And that's what I'm doing at the moment. I do have to address the point about SJTC ostensibly making the application. And I will do that when I deal with my main appeal submissions very shortly. But I do make the point, because I have to, that in circumstances where even it was known that there were disputes over this, such that it was not an agreed position that there was a conflict of interest. And indeed, in my respectful submission, there was no proper conflict of interest. But in those circumstances, what was needed was proper factual scrutiny. Injunctive relief to protect the position may be one thing, but to make a final determination was inappropriate. The final authority I must go to, and I'll do it swiftly, I think there's only one paragraph I have to go to, and I trailed this yesterday. Tab 13 of this bundle, it's the Court of Appeal decision in the NatWest and Lucas case involving the estate of Jimmy Savile. And my lady, Justice Gloucester, appeared in and agreed with the leading judgment of Lord Justice Patten. And the relevant part of his decision can be seen from page 329, 329.
What is this reference, Mr. Cumming? I'm sorry, I didn't get that.
Sorry, Supplemental Authorities Bundle, tab 13, page 329.
And the name of the case?
It's NatWest and Lucas in the Court of Appeal in England. It's the estate of Jimmy Savile.
Page 379?
329.
329.
Now I go to 329 just to show that at 82, his lordship referred to the locus classicus, Letterstetten Breurs, and then at 83 is the key passage for present purposes. But as Lord Blackburn indicated in this passage, the direct intervention by the court in the administration of a trust or an estate by the removal of the trustee or personal representative has for the most part to be justified by evidence that their continuation in office is likely to prove detrimental to the interests of the beneficiaries. A lack of confidence or feelings of mistrust are not therefore sufficient in themselves to justify removal unless the breakdown in relations is likely to jeopardize the proper administration of the trust or estate. This is something which requires to be objectively demonstrated and considered on a case-by-case basis, having regard to the particular circumstances. And my submission is that that consideration, having regard to all the particular circumstances, cannot take place properly on this occasion. That's all I plan to say on that point, but I do emphasise that it is a big step to remove a trustee, and proper process matters because of the substantive consequences and because what is alleged against the trustee has to be clearly identified, because mere mistrust, mere friction is not in and of itself enough. So against that, what exactly is the problem and was the problem said to be with SJTC before Mrs. Justice Subare Williams? Well, the Attorney General has never criticised SJTC, or I add Mr. Watlington or Mr. Ferguson. The DOJ is happy, we saw yesterday, with the involvement of Mr. Watlington and Mr. Ferguson in the trust. The hostility comes and came from Mr. Gilbert, and effectively in succession through him, Medlands, and Mr. Lang and Mr. and Mrs. Brockman. All that was said in essence at the December hearing against SJTC was that the appointment of Mr. Watlington and Mr. Ferguson should be seen as Mr. Tameen exerting personal control over the trust itself and those proceedings against him, which I'm just for shorthand going to call the Tameen proceedings. As has been demonstrated since, though, that suggestion was entirely misplaced, as was any suggestion that there was any basis to think Mr. Watlington or Mr. Ferguson would inappropriately administer the trust, such that the proper execution of the trust was in jeopardy. So far as I'm aware, and at least so far, no allegation to that effect is made at this hearing. And as I said yesterday, following the Chief Justice's decision, the independence and standing of Mr. Watlington and Mr. Ferguson should rightly be unimpeachable. In any event, the concern was limited to potential interference with the Tameen proceedings, in which Mr. Tameen has, and I don't shy away from this, has a personal interest. But the significance of the trust in those proceedings has been exaggerated, and I would say over-exaggerated. SJTC, as was discussed yesterday in questions from the bench, is controlled by its directors and not by Mr. Tameen. Its directors aren't creatures of Mr. Tameen or controlled by Mr. Tameen. And so there's no conflict of interest as far as SJTC is concerned. There's no principle of law, and in my respectful submission, nor could there be, that a company is conflicted from acting as a trustee necessarily just where an indirect shareholder, such as Mr. Tameen, is being pursued by the company.
Has he paid the money back yet?
I will need to check exactly what's happened. My understanding is it's all paid in court. And I will come on to that because there's a very good point arising from this. Since SJTC, I'll deal with it now, it's just convenient. Since SJTC became under the control of Mr. Watlington and Mr. Ferguson, in March last year, when the Chief Justice discharged the ex parte injunction and struck out those proceedings as an abusive process, SJTC has still been a party to those proceedings, and there's no suggestion that it's misconducted itself in any way. Certainly hasn't sought to get the proceedings dismissed or done anything. Moreover,
could I just understand this? The money has been paid into court by Mr. Tameen, has it?
That is my understanding. I may be wrong.
Disputing that the trustee, whoever the trustee may be, is entitled to the funds?
Well, it might be best for Mr. Brownbill to address exactly what Mr. Tameen's position is, because I don't want to risk his position either way. What I can say is that and I'll do this in shorthand because I don't want to misguide the court at all. Mr. Tameen says it's all a put up at the hands of Mr. Brockman as retaliation because I've helped the DOJ. Now, SJTC can't.
Can I be clear? If Mr. Tameen is saying that, does that mean he's disputing that the money's repayable?
I think it must. I think it must. But I don't have all the detail at my fingertips. And I hope that answers your ladyship's question on that. But just to finish my point on those proceedings, Medlands has not taken steps since it was appointed as trustee under the December order more than 12 months ago to be made a party to those proceedings. One would have thought if Mr. Watlington and Mr. Ferguson, as directors of SJT, and indeed SJT itself, was such a vast threat to those proceedings, they'd have made absolutely certain that would happen. But they haven't made sure that it happens. And indeed, it's not suggested that SJTC has done anything somehow to jeopardize those proceedings. But that bleeds into the other point I have to make about those proceedings. And I made it yesterday, but I must make it in this context again. Overwhelmingly, those claims are the claims of Spanish Steps Holdings, not of SJTC. And again, this waters down the conflict argument. It was presented as all very simple and straightforward at the hearing below, wrongly. But that's really challenging. It might be helpful to look at the structure chart that Mrs. Brockman has provided in bundle 9 at tab 78, page 5653.
Isn't Spanish Steps Holdings an underlying company of the trust?
It is, under the control of its directors. And its directors are the directors of Medlands.
So it's an asset of the trust?
Well, its shares are assets of the trust. The structure chart is in bundle 9, tab 78, page 5653. And this is significant. When I refer to the shares, my lord, I wasn't seeking to be practically unrealistic at all. The reason it matters or may matter is in circumstances where Mr. Watlington and Mr. Ferguson have said that they will give an undertaking not to take any step outside the ordinary administration of the trust, which would include replacing or removing the directors of Spanish Steps Holdings without directions from the court beforehand. And indeed, they would extend that undertaking to not taking any step in relation to the administration of the trust without prior directions of the court, if that were thought appropriate. And that goes again, in my respectful submission, to the extent to which this is not some ploy by acolytes of Mr. Tameen to, as it was put in my submission very unfairly before Mrs. Justice Subert-Williams, to deliver the trust into the clutches of Mr. Tameen. In any event, you will see on page 56, 53, the structure chart there. While we're here, on the right-hand side, you'll see the trust at the top. And I should say the trust has a bank account in Bermuda with several millions in it that's in the name of SJTC.
Sorry, could you give me that reference again, please?
Yeah, sorry. So bundle 9, tab 78, page 5653, 5653. Top right-hand side is the trust itself. And as I say, it has a bank account in Bermuda with Bank of Butterfield, I think, that is in the name of SJTC. It's got millions in it. And that bank account has been left in the name of SJTC ever since December last year. And it's not suggested anything inappropriate has happened with that money. Curious if Mr. Watlington and Mr. Ferguson are such a threat. The trust also holds its shareholders' interest, its members' interest in Spanish Steps Holdings LLC in Nevis, and the directors of Medlands are the directors of that company, and also, I believe, directors of the subsidiary Spanish Steps Holdings Limited BVI. Spanish Steps Holdings Limited BVI, so far as we know, and of course we don't have the exact current position from the trustee, so everything I say is subject to caveats about change. Has 3 assets. From the right, it's got a 96% plus, I think, interest in Universal Computer Systems Holding, which is the company that said it can pay a dividend, but only if the trustee is who it wants the trustee to be. It also has an interest in Zephyr Investments Limited Bermuda, and it holds the common shares in the bottom left-hand corner of Point Investments Limited, a Bermudian company. The directors of that Bermudian company, as I mentioned yesterday, are Mr. Watlington and Mr. Ferguson. And that is because, as you'll see up to the left, the management share in that company is held by Point Investments LLC Nevis, and the members' interests in that are held by the Point Purpose Trust Bermuda, and Mr. Tameen is involved through that trust. Now, Point Investments...
What does that mean?
I beg your pardon, my lord?
What does that mean, that he's involved through that
he's I think, but what it really means, to be frank, is I can't quite remember the exact detail. I think he's director of the company that is trustee. But I may be wrong on that, and others may wish to correct me. But it's that or something practically the same as that. Point Investments Limited holds well in excess of its assets are in the billions. I think it's over $1.5 billion worth of value. It's what I talked about yesterday as being described by Mrs. Brockman as the primary investment vehicle of the trust. It's got investments in private equity funds, which I think are at least one of them involved in the matters that are subject to the US indictment. And it holds cash. A helpful summary of all of this is actually in Mr. Gilbert's affidavit for the hearing before Mrs. Justice Subert-Williams, which is in bundle 5. Bundle 5, tab 46, page 3295, 3295 of the bundle numbering. If my Lady Justice Gloucester's using the black bold bottom right numbering, it's page 145. So this is the part of Mr. Gilbert's affidavit when he was explaining to Mrs. Justice Sue Williams in December. It's not quite clear how much of this she actually read, but that was its purpose. He was explaining what actually was involved in changing as a result of the transfer of the trusteeship. You'll see at 128, he talks about agreements that he didn't think were relevant for current purposes. At 129, he says St. John's holds the shares in Spanish Steps Holding LLC. I'm advised these can be transferred from St. John's to the new trustee by a simple deed of assignment. There's a question which I don't think the court needs to trouble itself with greatly today over whether the assignment that Mr. Gilbert actually executed was effective, where he was entering into a transaction outside the ordinary course of business and was only one of three directors, only one of three directors of SJTC, and therefore didn't have authority to do that. But I don't want to get bogged down on that. As I've said, Spanish Steps has its own directors. At 130, there's a reference to the bank account that I mentioned myself. Second sentence says it's intended Medlands will open one or more new accounts at Butterfield Bank, and the funds in the St. John's Butterfield account will be transferred to the new Medlands account or some other account held by either Spanish Steps or Point. Well, that never happened. I think Mr. Watlington and Mr. Ferguson are the signatories on the Bank of Butterfield account as the directors of SJTC. And there's not any suggestion entirely properly that anything's happened in relation to those funds. 131, Spanish Steps and Point, so these are the subsidiary companies, have bank accounts at Mirabeau, Bank SYZ and Bank of Singapore. Those banks will need to be informed about the change of trustee. Well, the change of trustee itself doesn't change who the signatories on those accounts will be, because they'll be the directors of those companies or people authorised by them. And then at 132, St. John's has private equity investments. Well, that's not right. Point, as is acknowledged at the end of that sentence, Point Investments Limited has those private equity investments. And then there's a reference to the registered office. So there's not all that much. I'm not decrying its significance, because it is obviously significant, the trustee, but there's not all that much that necessarily flows from peril to the assets in relation to all of this. That was a bit of a diversion, for which I hope I'll be forgiven, but it will cut down what I have to say later. The other point about the Tamine proceedings that makes some of the criticisms that are now made really unattractive is that from the commencement of those proceedings, I think in 2018, all the way through until the 10th of December, when Mr. Gilbert issued his summons that led to the December order in 2019, all involved were content with SJTC remaining trustee, notwithstanding that Mr. Tamine was shareholder, and with SJTC being a party to those proceedings. Now, what may well be said is, well, yes, but Mr. Tamine has appointed Mr. Watlington and Mr. Ferguson. To which my response is, viewed properly, so what? Mr. Watlington and Mr. Ferguson have unimpeachable reputations, have acted entirely appropriately in all of this. They're perfectly appropriate people to scrutinise. The first time there's a suggestion of a problem in this regard is at the strategy meeting on the 2nd and 3rd of December 2019 that took place in London. And I'll come on to that again when I deal with the chronology as I come to the substantive appeal very shortly. One thing I should say, and I don't think it's going to be helpful to go through it in great detail, but I think I must, given some of the things that have been, some of the many things that have been flying around overnight. I've been talking about Point Investments Limited, and I said entirely accurately yesterday that there was no allegation, no suggestion in these proceedings that Mr. Watlington and Mr. Ferguson had misconducted themselves in that position. Now, there's certainly no proper allegation that can be made, but I believe from the fact that Conyers, now acting for Medlands, have sought to put certain documents in the hearing bundle, and also from certain comments that have been made on the chronology, that it might now be sought to introduce, no doubt to meet my argument, now might be sought to introduce some allegations into these proceedings. I'll deal with them in reply to the extent I have to. But my real submission on all of that is it rather underscores the unsatisfactory nature of effectively resolving the underlying matters on this occasion. I will, though, take you to the correspondence, just for completeness, that I mentioned yesterday, in which Mr. Watlington and Mr. Ferguson, as directors of Point Investments, were asking questions about the charitable giving in the DOJ in order to try to get comfortable with paying up some of the cash that sits with PIL to allow charitable giving to be supported. We can see this in Bundle 3, Hearing Bundle 3, at tab 19. And the best place to pick it up, I think, is 2286. Actually, that's not quite right. The best place to pick it up is page 2282. 2282. This is a letter from Wakefield Quinn, who represent the parent of Point Investments Limited, instructed, I think, by the people who are currently directors of Medlands and were at the time. The third paragraph down, it says, we set out below approximately $10 million of charitable gifts that are due to be paid this quarter by Medlands as trustee of the trust. Then it sets them all out. Then you see the reply on behalf of Point at page 2285, and the bit that I want to draw your lordship and your ladyship's attention to in particular is on 2286. There's an argument going on about redemption requests, which was signed by Mr. Gilbert when he was hopelessly conflicted as director of everything, at the same time as seeking to get his own personal trust vehicle appointed as trustee. At the top of 2286, Marshall, Deal and Myers say, without prejudice to all this, we're nevertheless grateful for the further information provided in your letter of the 24th of July. I know this is 4 days later, 28th of July, but in order to allow our client and its directors to give full consideration to your correspondence, please now provide the other important information we sought, identifying the dates and the details and how this had all arisen. And I'll ask your lordship and your ladyships just to read that at point 1. Point 2, please identify the amount of liquid funds presently available to Medlands and provide a full explanation of why your client and your client's shareholder are unable to realise assets to meet these commitments. Again, a perfectly appropriate question to ask. And then A and B, please provide A and B, please provide a copy of the communications with the DOJ by which, and then it's quoted, the DOJ has been informed of the nature and amount of the gifts, which show the DOJ has taken no steps to prevent such payments being made. Well, with the US government breathing down someone's neck, that's an entirely appropriate request in my respectful submission. And then B, confirm the directors of each of your client shareholder and Medlands are prepared to provide written undertakings to the effect specific sums transferred in accordance with your request will be used solely for the specific charitable payments identified in your letter, and that Medlands otherwise has insufficient assets to allow them to be made. Well, again, in the context of this matter, entirely appropriate. And then 4, in the context of the DOJ investigation, when you let us know, we're going to seek the DOJ's consent. The reply is baffling over the page at 2287. First full paragraph, we don't propose to respond in detail to the bizarre position taken by your clients. Well, we don't need to get into that on the redemption request. Second full paragraph, in light of the recent revelation that Point defaulted on a commitment of 625,000 due on the 1st of July. There's other correspondence on that, hotly disputed issue. Our client has no confidence that PIL has at Point has any intention of complying with our request to transfer 10 million for charitable distributions. Accordingly, we don't consider there's any purpose served by wasting further time and costs on this line of correspondence. Well, wow. My submission, and I'm hoping to wrap up what I have to say on the respondent's notice before the break in 9 minutes, is that SJTC in no way represents an inappropriate risk to the trust or to its affairs or to the proceedings in which Mr. Tameen has an interest. That is a fortiori where Mr. Watlington and Mr. Ferguson have proffered undertakings not to take steps in relation to the affairs of the trust without directions, and where Mr. Tameen has proffered his undertaking not to interfere with the composition of the board of SJTC without a prior court order. Aside from that, the only criticism, as far as I can tell, but this is another reason, frankly, why matters like this ought to be raised by writ so that everyone knows just what is being said with appropriate precision. The only other criticism of Mr. Watlington and Mr. Ferguson, and therefore of SJTC, seems to focus on the degree to which Mr. Watlington and Mr. Ferguson have contacted Mrs. Brockman. Well, even if what Mrs. Brockman contends were correct, that can't be such as to render SJTC unsuitable as trustee. And in any event, it overlooks the crucial facts that within days of them being appointed as directors of SJTC, they were injuncted in proceedings brought as an abusive process by Mr. Gilbert, injuncted from acting in relation to the affairs of SJTC. How could they properly have written to Mr. or Mrs. Brockman at that point? And then when they were released from that injunction in March last year, they'd discovered not long before that release that SJTC was no longer the trustee because of the manoeuvre that took place in December. Strategized at the meeting on the 2nd and 3rd of December, attended by representatives of Miller and Chevalier, who'd been Mr. Brockman's attorneys. And at all times since, they've made strenuous efforts to find out just what happened. And it wasn't until the 25th of November last year, with arm firmly placed behind back, that those who knew what had taken place thought it appropriate to tell SJTC. And the Court of Appeal wasn't even allowed to find out until the 29th of December because of the tortuous, wrong construction given to an order of Mrs. Justice Subare Williams. And she's since confirmed that it was wrong. It was also wrong of Mr. Machel yesterday to suggest that SJTC and its directors had never referred to the interests of the beneficiaries. We don't need to turn it up, but our reply submissions in relation to the opposition to an enlargement of time for this appeal, paragraphs 35.3 and 35.4, bundle 4, tab 29, page 2587, address just that. And elsewhere in that document, SJTC contemplated HSBC being trustee and probably being more appropriate than Medlands. And I emphasize at that point, Mr. Gilbert remained a director of Medlands. So my submission in summary is that the position in respect of the underlying issues addressed by the November and the December orders needs to be addressed properly at first instance before the future administration of this trust can be addressed in a sustainable way. As a result of the nature of the orders under appeal, the way in which they were procured, and the fact they have been and still are being used as a means of denying SJTC information to which it's entitled, which may very well be of significant importance to the court when the court is asked to exercise its jurisdiction to give its imprimatur to a trustee. That information needs to be able to be put before the court, and there needs to be some time for reflection before an order is made in relation to the trusteeship. The fresh start that's been referred to can and should only properly come after what has been going on in respect to this trust has been properly investigated and properly and transparently resolved.
Mr. Cummings, just by way of clarification, what information is it you say SJTC would be entitled to, and in what context?
It is records from Conyers, who were its lawyers, from the time when Conyers were its lawyers. It is records held by Mr. Gilbert from the time when he was a director of SJTC. It is other material and records held by other agents of SJTC, including Miller and Chevalier, to which SJTC is entitled. And the Chief Justice has...
Why wouldn't SJTC be able to get those records if he's entitled to them by an order of the court?
It's an excellent question.
Why would it need to be restored as trustee to be able to have access to them?
I'm not saying it needs to be restored as trustee to have access to them, my lord. The problem is that Conyers, Medlands, Mr. Gilbert, Miller and Chevalier have all said that their position has been the December order is such that you, SJTC, are no longer entitled to them, even though SJTC properly is.
Yeah, that is wrong. That's a matter that the court can set right.
Yes, and what's
on an application of SJTC.
Well, indeed, my lord, and I'm not saying this is a reason to make any particular order in relation to the November and December orders, apart from the obvious abuse of process, which I'll come on to. What I'm saying,
I must have misunderstood. Thank you.
No, I do need to grapple with this. What I am saying is that in circumstances where these orders, wrongfully obtained, have been used to stop SJTC having a full picture, and what SJTC had to do is bring proceedings before the Chief Justice that were determined on the 14th of December, and he determined we were entitled to this information as against Mr. Gilbert and as against Conyers, and now we need to go out of the jurisdiction and deal with Miller and Chevalier. What I do say is that should be allowed to happen. And I also say it's striking that it's only 2 weeks after that Mrs. Brockman gets her skates on and the application is issued. It may be completely coincidental. I'm not saying I know for sure one way or another. I don't. But the court, when it's being asked to exercise a precious jurisdiction, ought to be satisfied. And ought to be satisfied on a rigorous basis, given the context of this trust and given what's taken place, both in relation to the matters that the US government's concerned about, and insofar as these are not matters the US government's concerned about, I don't concede that, and in the extraordinary circumstances of November and December last year, which I'm going to address as part of my submissions on the main appeal, probably, unless there's more questions, after the short adjournment.
Right. Well, unless there are any questions from Justice Gloucester or Simmons, we shall take the 15-minute break now then.
I'm grateful, my lord.
Thank you.
I just ask that the parties turn off their cameras and mics, please, and the judges can go to the breakout room.
Shall we join the breakout room, Mr. Coelho?
No, I actually feared that you had dropped off the call because I didn't see you there. Do you want the others to come over or do you want to go back?
Oh, they're there. Let me go back and then we will come over together.
Okay.
Right, we are resumed.
I'm grateful, my lord. Turning then to SJTC's appeal. It may assist to begin by running through the factual background, as it's important to have that clear. The best place for my purposes to do that is to begin with my skeleton argument, which you can find in the submissions bundle behind tab 1, and I want to pick it up at page 8, paragraph 31. Submissions bundle, tab 1, page 8, paragraph 31. So the starting point is that prior to the 25th of October 2019, Mr. Gilbert was the sole director of SJTC. On the 25th of October 2019, Mr. Watlington and Mr. Ferguson were appointed as directors as well. So from that date, the board constituted Mr. Watlington, Mr. Ferguson, and Mr. Gilbert, the three. Paragraph 33, you'll see, says just a little bit about their backgrounds. Mr. Watlington's one of the longest serving and most experienced lawyers in Bermuda. And Mr. Ferguson has been in practice in Australia since 1991, and indeed is no less than a former president of the Law Council of Australia, which I understand to be the equivalent of the English Law Society and the Bermudian Bar Association. You will see then at paragraph 34 is set out bylaw 4.1 as amended in April 2013 and as in effect at the time 25th of October 2019. And I would just ask your lordship and your ladyships to read that. And the conclusion of that is that following the appointment of Mr. Watlington and Mr. Ferguson on the 25th of October, there were three directors who were together charged to manage and conduct its business. And as such, no one director could do so unilaterally. Mr. Gilbert, the director of SJTC at that time, subsequently sought, wrongly, as the Chief Justice has found, and as is in my respectful submission otherwise self-evident, he sought to engineer a situation which he exploited by pursuing the administration proceedings on his own, The administration proceedings referred to in my skeleton argument are the proceedings at first instance from which this appeal is brought, and in which the November and the December orders were sought and obtained. And that happened without the knowledge at all at the time, still less the consent of Mr. Ferguson or Mr. Watlington. There was no warning in advance, and efforts were made otherwise to keep them thoroughly in the dark until the orders had been made. And all of the orders, both of the orders, were made without the authority of SJTC. Now, the best place to pick this up is the decision, the judgment of the Chief Justice in March last year, which we see in Authorities Bundle 3 at tab 89. And I'd like to pick it up at, actually, I'd like to pick it up, if I may, at page 1907, just because this may assist whilst a chronology is being agreed. At page 1907, your lordship and your ladyships will see that the Chief Justice sets out something of the background, and that runs all the way through to page 1913, page 1913. We don't need to read it now, but the court may find it of assistance to read that if there is a suitable juncture. Then on page 1918, 1918, at paragraph 35, we pick up the Chief Justice's judgment on the question of authority. Page 1918, paragraph 35. The Chief Justice says, as noted above, and we've looked at this in my skeleton argument already, bylaw 4.1 of SJTC's bylaws provides, assuming Mr. Watlington and Mr. Ferguson were validly appointed as directors on the 25th of October, there were 3 directors of SJTC who were charged to manage and conduct its business. On that basis, counsel submits for Cabarita, Mr. Gilbert did not have authority on his own to commence the present proceedings. So to be clear, this decision is given in the corporate proceedings challenging the appointment of Mr. Watlington and Mr. Ferguson, brought wrongly by Mr. Gilbert in the name of SJTC on the 1st of November, the same day that Mr. Gilbert wrongfully procured the November order, which is the subject of the appeal in these proceedings. Paragraph 36. Counsel submits that to commence proceedings in that name, SJTC required a valid board resolution. However, no board resolution could have been passed without either a unanimous written resolution of all directors, see bylaw 8, or a resolution being passed by a majority at a quorum board meeting properly convened. There was no such resolution, and it follows counsel submits Mr. Gilbert had no authority to instruct Conyers to commence the proceedings. Paragraph 37. I accept the general proposition that the power to conduct affairs of a company lies with the directors as a body, if more than one, and requires a board resolution. I note the generality of that, to conduct affairs. Where there's a board of directors, a single director has no power to take any particular action on behalf of the company unless such a power has been delegated to him by the board of directors. On the assumption that on the 1st of November, when the summons was filed in these proceedings, the board comprised 3 directors, it must follow that Mr. Gilbert had no authority to institute these proceedings on behalf of SJTC. Paragraph 38 over the page. In the circumstances, the critical issue is whether Mr. Watlington and Ferguson had been validly appointed as directors of SJTC when these proceedings were commenced on the 1st of November 2019. We see his conclusion on that at paragraph 82 on page 1932, page 1932. In the circumstances, I conclude that Mr. Watlington and Mr. Ferguson were validly appointed, and there's a typo there, it should say, I think, on the 25th of October 2019, as a result of the operation of the geomatic principle. I do not accept the submission that in this case, the geomatic principle does not apply because the underlying transaction, i.e. their appointment, is dishonest or not bona fide, and he goes on, or that the appointments were made by Cabarita with a view to furthering the interests of Mr. Tamim, its sole director and shareholder, and that they were not properly made in the interests of SJTC, but rather for an ulterior advantage. Shades into the very issues we've been grappling with in the past day and a half. He says at the end of that paragraph, all that there were defects in compliance with procedural formalities designed to protect the interests of a third party. Paragraph 83, it follows that from the 25th of October 2019 onward, the board of directors of SJTC comprised Mr. Gilbert, Mr. Watlington and Mr. Ferguson. The commencement of the proceedings on the 1st of November required a resolution of the board of directors. Mr. Gilbert, acting alone, had no authority to institute these proceedings on behalf of SJTC. As no relevant board resolution authorising these proceedings was passed, it follows these proceedings were commenced without any proper authority from SJTC. On the 1st of November 2019, as we've seen, Mr. Gilbert issued that writ seeking the final injunction to stop Mr. Watlington and Mr. Ferguson from acting as directors of SJTC. And I've said that's the same day as the November order. It's a point that I pick up at paragraph 38 of my skeleton argument, which if you put it away was submissions bundle, tab 1, page 9 now, paragraph 38. Then we see from the next paragraph, on the 5th of November, Mr. Gilbert, again wrongly purporting to act on his own in the name of the appellant, SJTC, instructed Conyers to issue an ex parte summons in the corporate proceedings, seeking an interim injunction, this is the ex parte order I've spoken about, against Mr. Watlington and Mr. Ferguson to prevent them from holding themselves out as directors of SJTC. An important point then at paragraph 40, Mr. Gilbert's affidavit filed in support of the summons stated he was seeking interim relief in order to do no more than hold the ring. I'm not sure we need to turn it up, but for your notes and future reference, you can see that in bundle 2, tab 17, page 266. Bundle 2, tab 17, page 266. Mr. Gilbert also assured the court neither the independent directors, that's Mr. Watlington and Mr. Ferguson, nor the Brockman Trust, where the SJT's interests were essentially those of the Brockman Trust, would sustain any prejudice if the independent directors were prevented from discharging their role whilst their authority was scrutinised. And that comes from the same paragraph in Mr. Gilbert's affidavit. The independent directors would suffer no prejudice. Then the hearing takes place on an ex parte basis before the Chief Justice on the 6th and 7th of November. Conyers argued, purporting to do so on behalf of SJTC, but not doing so on behalf of SJTC. It was an abusive process. But there was a serious issue to be tried between the company, that's SJTC, and Mr. Watlington and Mr. Ferguson on serious allegations of impropriety and an alleged conspiracy between them and Cabarita, through which Mr. Tamim is involved, of course. The Chief Justice granted an interim injunction, and we see that in bundle 4 at tab 22. I can just give you the reference actually, because the key paragraph's quoted in my skeleton argument. Bundle 4, tab 22, pages 2443 to 2445. The salient part that's relied on subsequently, which we need to focus on today, is paragraph 3. The plaintiff may continue to conduct its business in accordance with its bylaws as if Mr. James Gilbert is sole director without regard to the member's decision dated the 25th of October 2019. That's the decision appointing Mr. Watlington and Mr. Ferguson. Now, given that Mr. Gilbert had represented to the court that the purpose of that injunction was, quote, to hold the ring, unquote, and that there was no risk of prejudice to the independent directors who may well have wished SJTC to remain trustee of the Brockman Trust, or to the affairs of SJTC, which of course may properly and does consider that it should have remained trustee of the Brockman Trust. It didn't permit Mr. Gilbert to take any steps that were outside the ordinary course of business. And over and above that, it certainly did not permit him to take any steps which fundamentally altered the position of SJTC. Now, that point's of crucial importance, and it's clear from the Chief Justice's own judgment. Again, bundle 3, tab 89. Sorry, no. The Chief Justice's judgment giving the interim injunction is not actually in the authorities bundle. We need to turn to hearing bundle 3, main volume 3, tab 18, where we have a transcript of what the Chief Justice said when he was granting the injunction at page 1480, 1480. Just to pick it up, it begins for completeness at page 1477, page 1477. So that's main volume 3, tab 18, page 1477. And it's a short judgment which underscores the fact it was being made ex parte, there'd been oral submissions, and it underscores the informality of the judgment. But the crucial part is on page 1480, the final 3 lines. I will also make an order that the existing director can continue to conduct the business as per normal, as suggested by Mr. Adamson from Conyers, who was conducting this part of the hearing. There was a bit of a spat about this at the return date, which regrettably was booted off for multifarious reasons to the 20th of February last year. And at that return date, and you can pick this up again, I'm not going back to that transcript of the judgment. Your lordship, your ladyships may wish to read all of it at a suitable juncture. And I can pause now if now is the suitable juncture, but I didn't intend to take you through it now. So back to my skeleton argument at paragraph 44.2. On the 20th of February, during the final hearing, the Chief Justice made an order that paragraph 3 of the order itself, so the words on the face of the order, be amended to clarify the position that had already always pertained, namely, that his order did not permit Mr. Gilbert to take any steps which are outside the ordinary course of business. And by this point, of course, the Chief Justice knew what had taken place improperly using his order. If I could ask you to go to bundle 2. Well, in fact, I don't need to take you to bundle 2, but for your reference, if you want to go to the hearing on the 20th of February, I'm trying to make sure I finish by lunchtime. The reference is bundle 2, tab 17, page 811 to 812. The Chief Justice grapples with this question, as your lordship and your ladyships have already seen, but I will take you to it again because it's important. In Authorities Volume 3, Joint Authorities Volume 3, at tab 90, at page 2051, in paragraph 246. This is a decision of the very judge who made the order, absolutely best placed to know the order that he made, had heard the evidence, had read the evidence, about the injunction only holding the ring, had read the evidence there could be no possible prejudice. And his conclusion as to what paragraph 3 of the order meant at paragraph 246 is, here, in view of the court, the application to change the trustee prior to the inter partes hearing, that's in February 2020, was in clear breach of the representation made to the court that the sole purpose of the ex parte order was to preserve the status quo. The ex parte order of the 6th of November conferred no authority on Mr. Gilbert to make an application on behalf of SJTC to change the trustee of the Brookman Trust. The statement made by Mr. Gilbert and Conyers in the trust proceedings, that's the proceedings from which this appeal is made, that paragraph 3 of the ex parte order gave Mr. Gilbert the authority to make the application to change the trustee was not an accurate statement of the authority conferred on Mr. Gilbert. These manoeuvres resulted not only in a serious breach of the duty of full and frank disclosure to the court, because of course, Mr. Gilbert never came back to the Chief Justice to say this is what we're going to do, or this is what we've done until the next year. These manoeuvres resulted not only in a serious breach of the duty of full and frank disclosure to the court, but also deprived SJTC of its right to make appropriate representations to protect its interests at the hearing before Mrs. Justice Sue Williams on the 19th of December 2019. I add there, because it's very important on this appeal particularly, that it deprived SJTC of the right to make appropriate representations to protect the beneficiaries' interests at the hearing on the 19th of December 2019. The conduct that he addresses at paragraphs 21 to 50 and highlighted above reaches, in the court's view, the threshold of serious negligence.
We have read this judgment, you know. You were told that at the beginning by the President.
I'm grateful, my lady. I'd forgotten that, but I think it's important that I emphasise, certainly that's the last paragraph I plan to go to, that I emphasise that paragraph because of the authority I'm now going to go to make good, finally, insofar as it's required, the point that I'm now making. That authority is in Supplementary Authorities Bundle at tab 15A. Judgment of the Privy Council in Sanssouci Limited and VRL Services Limited. And the key paragraph is on page 391.6, 391 spot 6. I hope these updates have made their way.
You said tab 15A?
15A, I'm hoping that your lordship has a 15A.
I don't seem to have that. What's the name of the case?
It's Sanssouci Limited, S-A-N-S, new word, S-O-U-C-I Limited, against VRL Services Limited. It's a Jamaican appeal, 2012 UKPC 6. Those instructing me will make sure that both this authority and a proper electronic, an updated electronic supplementary authorities bundle find their way to you as swiftly as possible. In the interest of time, I may just read out, and it will hopefully appear accurately on the live transcript, the key part of paragraph 13(1)(3) of the judgment. There's submissions that say, well, there's various submissions made about the scope of the particular order in that case. I won't get into the dregs where you don't have it in front of you. And at paragraph 13, the Privy Council says, in the opinion of the board, the approach that was discussed, this approach to the construction of a judicial order is mistaken. Then 1, 2, 3, 4, 5, 6, 7, 8, 9 lines down, the board is unable to accept various propositions that were made because the construction of a judicial order, like that of any other legal instrument, is a single coherent process. It depends on what the language of the order would convey in the circumstances in which the court made it, so far as these circumstances were before the court and patent to the parties. The reasons for making the order, which are given by the court in its judgment, are an overt and authoritative statement of the circumstances which it regarded as relevant. They are therefore always admissible to construe the order. In particular, the interpretation of an order may be critically affected by knowing what the court considered to be the issue which its order was supposed to resolve. And we've seen the conclusion of the relevant judge in this case, the Chief Justice, in the paragraph.
I'm sorry to interrupt, but if my learned friend's going to go to this authority, he needs to read the first 2 sentences of paragraph 16.
If my learned friend wants to make submissions in his second round in due course, then he can do. I am keen.
No, I would like to have it now, please, because I don't have the authority.
There are only 2 sentences that they read. Of course, it does not follow from the fact that a judgment is admissible to construe an order that it will necessarily be of much assistance. There is a world of difference between using a court's reasons to interpret the language of its order and using it to contradict that language.
Yes, well, I haven't got that judgment either. So you say you'll ensure it gets to us, Mr.
We will. I'm hopeful that while I'm still on my feet, it will land in the appropriate inboxes. And I'm very sorry it hasn't found its way to you already. So as we've seen, the interim injunction, the ex parte order, was later discharged, but only after the November and December orders that are under appeal had been made. Strikingly, by the time the return date happened in February 2020, Mr. Gilbert was no longer pursuing allegations of collusion or allegations of conspiracy against Mr. Watlington and Mr. Ferguson. His complaint was instead, as I say at paragraph 45 of my skeleton argument, no more than a contention that the subjective intention of Mr. Tamine somehow ought to affect the validity of the independent director's appointment. And I've taken your lordship and your ladyships to what the Chief Justice's ultimate conclusion was on that. Since, of course, the appointment of Mr. Watlington and Mr. Ferguson and the termination upon that appointment of any right for Mr. Gilbert to act unilaterally in the name of St. John's Trust Company, Mr. Gilbert obtained both the November order and the December order. They were both wrongfully obtained. And you can see that from the reasoning of the Chief Justice at paragraph 238 of his judgment of last December. It's set out at paragraph 48 of my skeleton argument. I'm conscious of the indication that you've all read that, and I won't labour it again. The first time after that December order had been made that Mr. Watlington and Mr. Ferguson even heard of relief being sought in any other legal proceedings after they'd been appointed was on the 6th of January last year, 2020, when they received Mr. Gilbert's third affidavit filed in those corporate proceedings that had been heard by the Chief Justice. That was over a month after the November order and some weeks after the December order had been granted. And all that was said in that, in the final paragraph, paragraph 25, was that Medlands had been appointed trustee of the Brotman Trust by an order on the 19th of December. He did not choose to exhibit it or to disclose the order, and chose not to mention that he was the sole director and sole shareholder, sole member of Medlands. He first mentioned the November order in a further affidavit, his fourth in those proceedings, at paragraph 27 on the 24th of January 2020, but he didn't elaborate on what it had done. And the appellant did not see at all or even learn the terms of the order apparently made on its application until the 25th of November last year, barely 2 weeks before we had to lodge our skeleton argument. SJTC and its independent directors did receive a redacted copy of the December order, which I think was even more extensively redacted than the one that my lord was looking at one stage yesterday. It received that on the 15th of April, but we didn't even know who the parties were from that, because there was a separate schedule that identified the parties. And so a look back at the order will show how hard to begin to comprehend the order it was without knowing the identity of each of the different parties. And again, it wasn't until the 25th of November last year that SJTC even saw a proper copy, the one in bundle 5, of that December order. Now, what took place is all the more extraordinary and, in my submission, unacceptable, where Conyers, who at the time were SJTC's own lawyers, has recently confirmed, I say they were their own lawyers, and the reason I paused was because they weren't authorised to be taking any of these steps properly on the part of SJTC. They were really acting as lawyers to Mr. Gilbert at this point. But Conyers has recently confirmed only since the draft judgment of the Chief Justice was handed down in December, that this was part of an intentional strategy to keep the independent directors, Mr. Watlington and Mr. Ferguson, in the dark. Now, I can make that good from a letter written by Conyers in December, which I will go to now, but I do hasten to say that it is something of a tool of advocacy. So it carries that health warning. It's bundle 8, hearing bundle 8, tab 67. Page 5571. In fact, it's probably best to go to 55770 first, 5570. Bundle 8, tab 67, page 5570. You'll see it's a letter written to Medlands. And you'll see from page 5571, the 4th paragraph from the bottom, the 4th paragraph after the numbered paragraphs end, says the Conyers team travelled to London to attend a 2-day conference with leading counsel and the rest of the team, whatever that means, to discuss the predicament facing the trust and overall strategy on the 2nd and 3rd of December, defined as conference. The conference was attended by some 9 lawyers, including Mr. Adamson and Mr. Elkinson from Conyers. Uncertainties over the beneficial class, identity of protectorship, as well as the trustee itself, and issues relating to the holding structures within the trust, and this is the emotive language, which allowed Mr. Tamming to potentially seize control at any moment, and I add again, those had been in place for quite some time, meant that there was a perceived, clear and present danger to the trust, and no one other than SJTC could likely take action to counter the threat. And again, it's not quite clear what that is actually meant to mean. The view of the team was the failure to act by SJTC would be a breach of trust by SJTC. After debate, it was concluded that SJTC should seek the transfer of the trust to Medlands. Given the perceived risk to the trust posed by the new directors, whose motives were unknown, it's important that, it was clear to the team that they could not be informed. There was no reason, in my respectful submission, why that was the case, where they had been injuncted by the Chief Justice from acting in relation to the affairs of SJTC. We know also from documents that have very belatedly been disclosed by Conyers to SJTC as its former client, that Miller and Chevalier were in attendance at this conference. They were some of the rest of the team. And we know, of course, that Miller and Chevalier have been Mr. Brockman's attorneys. So returning to my skeleton argument and picking up the thread, paragraph 53, it wasn't until the end of March 2020 that Mr. Watlington and Mr. Ferguson and Cavarita, that's SJTC's shareholder, were able to secure the discharge of the interim injunction and the striking out of the corporate proceedings. And we've seen the judgment on various occasions by which that was done. I'd ask your Lordship and your Ladyships to read subparagraphs 54.1 to 54.4 of my skeleton argument, which again just draw out 4 important points to bear in mind for what's to follow from what the Chief Justice decided. So submissions bundle tab 1, page 13.
Yes, well, we have seen this just by reference to the judgment itself.
Yes, and
In
particular, his conclusion that the independent directors had been properly appointed on the 25th of October, with the consequence Mr. Gilbert had been acting without authority with regard to any actions purported to take in the appellant's name thereafter. So then we see at paragraph 55 to 57 a summary of the steps that had been taken by mid-December, by the 11th, by the date of this skeleton argument. It was mid-December, the 14th of December, to try to obtain documents from the administration proceedings. And I would just ask your lordship and your ladyships to read paragraphs 55, 56 and its subparagraphs, and 57.
I mean, again, Mr. Cumming, we have read your skeleton arguments very carefully. So, I mean, by all means, underline a point, but
I'm finished with it now, my lady. I only was doing this to make sure that
we've
clear
all done a lot of hard work in preparation for this hearing.
I'm sure, and I'm very grateful, and I'm grateful for the indication. So the reason I've been doing this in part is to allow me to recap what's an important building block in our appeal. And that is that Mr. Gilbert did not have authority to represent SJTC or to instruct Conyers to appear before the court on either the 1st of November or the 19th of December. You'd have seen paragraphs 30, or you have seen probably on many occasions, paragraphs 35 to 37 of the Chief Justice's decision in March. Exactly the same analysis there applies in respect of both those hearings and the proposition I've just advanced. This means that SJTC was not properly before the court on either occasion. Neither Mr. Gilbert nor Conyers had any right to be before the court telling Mrs. Justice Subert-Williams they were there for SJTC. Still less did they have a proper basis to present matters to the court on an agreed basis. And you'll recall that was the basis of the November order. I didn't go to the end of the transcript of the decision in November yesterday, but just for your notes, bundle 5, tab 44, page 3236, Mrs. Justice Subert-Williams says in terms that she's making the order on the basis that it's agreed. And I think goes on to say much more so than there's an odd word in there, but the impression is much more so even than she was anticipating. Mr. Ham has referred in his skeleton argument to a resolution of the 13th of September 2018. I dealt with this point yesterday. That's the resolution that allowed Mr. Gilbert to conduct investigations into the to do things in relation to the investigations. That does not extend to these matters. Just for the court's reference, that was dealt with yesterday's transcript day 1, page 102, line 6 to page 106, line 19. It is well established, if I need to make this point, I'll make it very briefly. It's well established that any act done by a director outside the scope of their authority, the authority that's conferred on them by the Articles of Association for the management of the business, is void under nullity for want of authority. And the authority for that is Bottomley's case, Re Alma Spinning Company, and that's Joint Authorities Volume 1, tab 14. I don't propose, in the interest of time, to turn it up, but I'd hope that proposition is uncontroversial. It follows from all of this that anything, unless Mr. Gilbert can somehow say that he was authorised by the Chief Justice's ex parte order in respect of the December hearing only, unless he can say that, then at all times, anything done since late October 2019 without the informed consent of Mr. Watlington and Mr. Ferguson has at all times been and remains void under nullity. Neither Mr. Watlington nor Mr. Ferguson provided any consent on any view, still less informed consent, to the procurement on the 1st of November of that order and the procurement on the 19th of November of the order that was then made. And the ultimate consequence is, where SJTC was not properly before the court or even represented at the hearings which led to the orders, as the Chief Justice has already determined in the corporate proceedings, SJTC was deprived of the opportunity to be heard, deprived of the opportunity to make submissions on the issues that arose for determination, and the court, importantly, was likewise robbed of the benefit of such evidence and such submissions. That was a breach of SJTC's right to a fair hearing, audiatur partem. And so there's 3 grounds of appeal that we advance. The first is that both the November and the December order were in these circumstances made contrary to fundamental principles of natural justice and SJTC's right to be heard, to be represented, and to make submissions, such that they fall to be set aside as of right. And connected to that is the judge's mistaken view, a mistaken view produced by Mr. Gilbert and Conyers, that SJTC was properly before the court on those occasions. That's ground 1. Ground 2 is that there had not been full and frank disclosure to the court, notwithstanding that a fiduciary who seeks relief of the kind in the orders in question is under a duty to provide full and frank disclosure. Now, as I said yesterday, I think that's common ground on this appeal. It was certainly the position advanced by Mr. Elkinson of Conyers, instructed by Mr. Gilbert at the hearings below, and I think in the December hearing only by Mr. Preston for Mr. Lang. And so for that reason, and others, the orders are an abusive process and fall to be set aside. The third ground is it was inappropriate for the judge to have made the orders where substantive and declaratory relief was being sought at the same time as bedo relief, where that substantive and declaratory relief turned on the very substance of the matters with which the bedo relief was addressed. Bedo relief was sought to pursue the corporate proceedings because, for shorthand, Mr. Tammy was said to be a rotter and this was all said to be a terrible conspiracy. At least that was how the corporate proceedings began. It's put rather differently at the December hearing, as we'll see. But bedo relief was sought in respect of those proceedings at the same time as Mrs. Justice Sue Williams was being invited to decide whether SJTC was appropriate to carry on as trustee of the trust. Those 2 things had to be decided by different judges. And these points are not simply petty procedural pedantry on my part. We're not concerned with missing a filing deadline. We're concerned with whether there was any proper judicial determination in circumstances where active judicial determination was sought for presumably very good reasons. A court order declaring these matters, ordering these matters was sought, and that is significant.
Can you just remind me, the bedo's application dealt with the corporate proceedings, but I thought they'd been concluded effectively.
Oh, no, not at all. Not at all. We'll see. But what was said, the bedo relief in respect of the corporate proceedings was sought on the 19th of December.
Yeah.
The final hearing, so 19th of December 2019, the final hearing really took place in February 2020, and it led to the CJ's decision in March 2020. What was said to Mrs. Justice Sue Williams was it was very important that she not only provided that bedo relief, but also provided the panoply of other relief before that inter partes hearing happened. So it was all deliberately sought before it was ever properly considered by the CJ. And then he goes on to strike it out as an abusive process.
And so the corporate proceedings have now come to an end.
They have. Well, save for consequential matters. They were struck out in March 2020, and there's consequential matters arising, including...
Like costs.
Well, the cost has been determined at a hearing that took place in November, and that I've taken you to parts of that transcript.
Yeah.
But there are outstanding issues over disclosure of documents and information by Mr. Gilbert and by Conyers. Conyers is involved in those proceedings in its own right, which is part of the reason we're a little surprised that it continues to act on behalf of Medlands. And so it's under that consequential relief that we got the material last week, for example, and there's an ongoing battle over whether we've got everything, and our position is that we haven't.
But why do you want that stuff? Why do you want those documents?
We want to know what happened in SJTC's name. And we want to make sure that the court that looks at what's happening for the future administration of this trust has a full picture of what really went on and why it went on.
I see. Thank you.
And that really actually has preempted the next point I was going to make. Your Lordship and your Ladyships would have seen my quotation of Lord Chief Justice Hewitt at the beginning of my skeleton argument. I'm not going to go to it. A long line of cases shows it's not merely of some importance, but of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. And I might say that's a fortiori with the DOJ looking on. Turning then to the first ground, breach of natural justice, the right to a fair hearing is a cardinal principle of natural justice. In my submission, it's hard to conceive of a more fundamental right, or one that the courts are and should be more careful to safeguard and vindicate when there's evidence that it's been transgressed. Any interference or proposed interference with the principle deserves the most exacting of scrutiny, and any determination tainted by a breach of natural justice should be set aside. That right is enshrined in the Constitution of Bermuda at section 6, subsection 8, and that can be found in Authorities Bundle 1 at tab 5, page 13. Any court or other adjudicating authority prescribed by law for the determination of the existence or extent of any civil right or obligation shall be established by law and shall be independent and impartial. And where proceedings for such a determination, that's the determination of the existence or extent of any civil right or obligation, are instituted by any person before such a court, the case should be given a fair hearing within a reasonable time. Now, in my submission, it is self-evident that the relief that I addressed yesterday in the November order and the December order affects the existence or extent of rights and obligations. That's precisely why the declaratory relief was sought in respect to the constitutional matters. It's precisely why orders declaring who was and was not trustee with all the rights and burdens that go with trustee, with being a trustee, was sought. It's why indemnities were sought. It's why orders were made about who assets should vest in. It's why orders were made, well, there were lots of reasons why these orders were made, but it's why orders were made dictating who Medlands as purportedly new trustee should instruct and authorising them to be able to instruct various people, including Miller and Chevalier, as their ongoing attorneys. They plainly concern determination of the existence or extent of rights or obligations. There's a suggestion, though, that trust proceedings somehow are different, or potentially, because I think it's put in both ways, that trust proceedings might be different insofar as they seek just directions from the trustee, effectively advice from the court, to use the language of the Australian statute that we looked at in the New South Wales case a little bit earlier. I don't accept any such distinction. It is, in my respectful submission, preposterous to suggest that the court can exercise a judicial function without adhering to the principle of audiatur partem, there shall be a fair hearing, or, and this is the other cardinal rule of natural justice, nemo iudex in sua causa. Is it seriously suggested that a judge who's got an interest in a trust could provide advice to the trustee? In any event, as I've said, the orders that we're looking at did determine the extent of rights and obligations, and so aren't part of, if you take the latter part of this attempted distinction, they weren't advice sought from the court. There was no endorsement of a decision that a fiduciary had taken. They were substantive orders affecting and determining the existence and extent of rights and obligations. There is also an argument advanced in Mr. Ham's skeleton argument, paragraph 18.3. We don't need to turn it up, I don't think. But there is an attempted analogy drawn between the exercise of a power by an office holder in a trust, i.e. a trustee or a protector, and the power of the court to grant relief determining rights, such as here removing a trustee. Well, in my submission, that's just no helpful analogy at all. We're dealing with two totally different creatures. We're dealing with a private person who has private rights, who can exercise them in the way appropriate under the law, and we're dealing with a court being asked to determine the extent and existence of rights and obligations. The position is, I concede, marginally different in respect of bedo relief. But although there are hints in the authorities that bedo relief should be different, in my respectful submission, it shouldn't. And it shouldn't because bedo relief itself also determines the extent of various rights and obligations. If a trustee has obtained bedo relief from the court before pursuing proceedings, beneficiaries are precluded from challenging the recoverability from the trust of legal expenditure that the trustee incurs in relation to those proceedings. But in any event, and in many respects, it's my last point on this, but it's in many respects the key point. Even if there might be an argument that you should adopt a slightly different approach in trust proceedings, it can't be the case that you jettison natural justice out of the window. So take a step back, and it's useful to do this by looking at Mr. Lang's respondent's notice, which is in bundle 1 behind tab B at, I think, tab 8 on page 37. And it's 2.5 that I want to focus in on. And there it's suggested, on behalf of Mr. Lang, in the circumstances of the present case, a decision not to hear SJTC in respect of the orders would have constituted a legitimate exercise of the Supreme Court's discretionary powers to supervise the administration of the trust and/or its discretionary powers of case management. He may come to this in his submissions, but in my submission, it is impossible to countenance on what proper basis Mrs. Justice Sue Bear-Williams could have said, no, actually, I don't want to, and I'm not going to hear from a party that may well be the de jure trustee of the trust, that I authorised in my order of July 2019 to continue administering the trust. I'm not going to hear them when granting the panoply of relief that was set out in the November orders and the December orders. What proper basis could there have been for such a conclusion? What conceivable harm could the trust have suffered if SJTC had known the hearing was happening and had come along to make submissions? And I say that a fortiori in respect of the December hearing, where the ex parte injunction was in place. What proper reason can there be for any of that? None is advanced, and in my submission there isn't any. It is in effect pretty much an attempt to achieve a similar fait accompli as that which was mistakenly pursued when the November hearing was pressed ahead with, notwithstanding Mr. Watlington and Mr. Ferguson's appointment, and then more egregiously, the December hearing was pressed ahead with, notwithstanding that and notwithstanding the Chief Justice's order. The point is basically, even if the principle is, and I don't accept it is, but even if the principle is that when justice demands it in proceedings like trust proceedings, some incursion into the principle of natural justice may be justified when justice demands it. That just can't be the case here. And in any event, this was not a decision the judge was asked to make. And one might rather ask why, if indeed the suggestion that it would have been entirely proper for her to decide, well, I'm not going to hear from SJTC, it doesn't need proper notice of this. I don't need to hear any submissions. I don't want to know what evidence or what submissions it might make. It's just not something she could or would have done, particularly where we've seen numbered recital 6 to the December order, which says that she thought everyone who needed to be before the court was before the court. And none, I should say, and I'm coming on to this, none of these issues were properly ventilated with her. I do need to touch briefly on authority, but I won't labour this. Joint Authorities Volume 1, tab 12, is the decision of the English Supreme Court in Al-Rawi and others against the Security Service. I'm sure the court is familiar with it. We can pick it up for current purposes at, I think it's page 180 of the bundle. It is.
That's the Joint Authorities Bundle.
Joint Authorities, Volume 1, tab 12. Page 180 of the bundle. Paragraph 1, Lord Dyson, giving, I think, the leading decision, says the issue that arises on this appeal is whether the court has the power to order a closed material procedure as described in the preliminary issue that was tried by Justice Silber for the whole or part of the trial of a civil claim for damages, and if so, in what circumstances it's appropriate to exercise the power. And then the background is set out at paragraph 2. But for present purposes, we can turn on to page 182 and paragraph 12. Secondly, trials, and I acknowledge this was not a trial with oral witness evidence, but insofar as what was happening was SJTC was being removed as trustee, for the reasons I touched on earlier, it may well have been arguable that it should have been. I know Mr. Machel cited a master's decision in, I think, the Schumacher case, but it's far from clear that that's absolutely correct. But in any event, later on in this judgment, as we'll see, they were focusing at a trial here on a trial because it was concerning a trial. The principles apply to other hearings as well, albeit I accept precisely what the rules of natural justice demand are not written in a tablet of stone. But anyway, paragraph 12, trials are conducted on the basis of the principle of natural justice. There are a number of strands to this. A party has a right to know the case against him and the evidence on which it's based. He's entitled to have the opportunity to respond to it and to any submissions made by the other side. The other side may not advance contentions or adduce evidence of which he's kept in ignorance. Then turning on to paragraph 19 on page 184. In proceedings not regulated by statute or statutory rules, it might be thought there are no limits to the inherent power of the court to regulate its own procedure, and that it has an untrammeled power to manage litigation in whatever way it considers necessary or expedient in the interests of justice. Then that's considered. And down at paragraph 21, Lord Dyson says, but even in an area which is not the subject of statute or statutory procedural rules, there are limits to the court's inherent jurisdiction to regulate how civil and criminal proceedings should be conducted. Then I'd ask your lordships to just read the rest of that paragraph. And also paragraph 22 that follows. When your lordship and your ladyships have read that, if you turn on to page 196, we have the judgment of Lord Hope. In the 5th line of paragraph 71, you'll see Lord Hope says the issue before the Supreme Court was essentially one of principle. And then I'd ask you to read paragraph 72. I've always believed a court of unlimited jurisdiction is the master of its own procedure. That does not mean the court can do what it likes. And then he goes on to expand on that in quite important terms. And then for completeness, you'll see at the foot of page 197, he says he dismissed the appeal for the reasons given by Lord Dyson. On page 198, we have Lord Brown's judgment. He also agrees the appeal should be dismissed. And then if we turn on to page 201, we have Lord Carr's decision. Paragraph 88, for the reasons given by Lord Dyson, with which I fully agree, I dismiss the appeal. I'd ask you to read paragraphs 89 and 90, though. the key nature of this right and its utter indispensability to the fairness of proceedings must occupy centre stage in the debate as to whether it may be compromised to serve the interests the defendants claim required to be served and which is said to justify a departure from it. Then on paragraph 97 on the next page, at paragraph 97 on the next page, one should not lose sight of the public interest in maintaining confidence in the administration of justice, referred to so pertinently by Lord Newburgh, the Master of the Rolls, in paragraph 56 of his judgment in the Court of Appeal. For the reasons he's given, I consider this is an extremely important consideration and one which should not be overlooked. And then finally, if your Lordship and your Ladyships turn to page 207, paragraph 115, Lord Mance, in the first 6 sentences, reiterates a point that I've already drawn from their Lordships' other judgments. If we keep this bundle open and turn to tab 27, we will have the decision in re Coroyn, I think it's pronounced, but that might be wrong. Decision of Mr. Justice David Richards, as he then was. Paragraph 3. He says that the proposed confidentiality regime for the trial that was under discussion here, which would have stopped the real parties to the trial from seeing certain material, would involve significant departures from the 2 fundamental common law principles applicable to trials in the civil as well as the criminal courts: open justice and then natural justice about knowing the case against you. We'll turn on to paragraph 40.
What paragraph is this?
Sorry, paragraph 3, my lord, on page 544. That's really just setting up the background to what was being decided here. It's paragraph 49. I really want to just flag on page 552. He's considered the case of Al-Rawi, which I keep mispronouncing, and I'm sorry, which we just looked at. And he says, pertinently in my submission, if a departure from the principles of natural justice could not be permitted in Al-Rawi, where it was said there were national security reasons why a party could not know material, a case where serious issues of national security are at stake, it can hardly be supposed that it will be available in a case concerning the financial circumstances of a party. And then I'd ask you to read paragraph 50 and his conclusion there. In my respectful submission, his conclusion is also the case in this matter. The final point I want to make in relation to the court's obligation in relation to preserving principles of natural justice goes to why it's important. And I'd like to illustrate that by reference to a Bermudian appeal authority in Authorities Bundle 2 at tab 61. It's the Ministry of Finance against AD. Joint Authorities Volume 2, tab 61. It's decision of Justice K. For the court's note, paragraph 6 on page 1235 encapsulates what the appeal's about. But for my purposes, I just wanted to turn to page 1239 and paragraph 19 of Justice K's decision. He says, for the reasons that he set out above, I share the view of Hellman J as to the position in this case. To do otherwise would be to countenance the possibility the subject of a production order could be prevented from ever seeing the filed documents. Not only would he be compelled to make an application pursuant to subsection 6b without prior knowledge of the filed documents or their contents. If the judge were then to refuse to grant a review, he could never gain access to the documents. I do not accept he be adequately protected by the fact the ministers considered it appropriate to seek an order and a judge on the ex parte application has seen fit to grant the order. Either or both may have been misled by the filed documents. And that's not meaning in an intentional sense even. It's just a matter of normal human disposition. Either or both may have been misled by the filed documents. Indeed, the requesting authority itself may have been misled by the information upon which it seeks to rely. All this could occur in circumstances in which only the subject of the production order has material which refutes or satisfactorily explains the information. And the consequences of that, or the ramifications of that reasoning in this matter, will, I hope, be obvious. So, in the circumstances of this appeal, SJTC wasn't before the court at either of the hearings. It had no opportunity to adduce evidence it considered in the best interests of the Brockman Trust, or to scrutinise the evidence that was before the court. It had no opportunity to make submissions of its own at these hearings, or to scrutinise material or submissions that others put before the court, or rather did not put before the court. The orders were made in breach, the November and December orders were made in breach of principles of natural justice. The consequence of that is that SJTC is entitled to have them set aside as of right. That is because where an order has been obtained following a breach of natural justice, such an order cannot be treated as having been a mere irregularity, because it's affected by what the authorities refer to as a fundamental vice. The matter has to be treated as so grave that the complaining party is entitled ex debito justicii to have it set aside. SJTC has been precluded from participating. Mr. Gilbert and Conyers had no right to purport to represent us at the hearing. We weren't there, and we weren't there through any negligence or fault that's properly attributable to the company. The position to make this good is set out by Lord Wilson in another English Supreme Court case, which is in Joint Authorities Volume 3 at tab 86, case of Serafin against Malkovich, and I'm sure I've mangled that pronunciation. And I'd like to refer to paragraph 49, which can be found on page 1836. He's dealing with a trial because this case concerned a trial. That makes no difference in my submission. 1836.
What tab number is this in volume 3?
86. Joint Authorities Volume 3, tab 86. And page 1836, 1836. Paragraph 49. What order should flow from a conclusion a trial was unfair? In logic, the order has to be for a complete retrial. As Lord Justice Denning said in the Jones case cited above, no cause is lost until the judge has found it so. And he cannot find it without a fair trial, nor can we affirm it. And here I say the matters determined in November and December can't be determined without a proper hearing and cannot be affirmed. And for the reasons I've made probably too much length already, in my respectful submission, this cannot be that fair hearing. Lord Reed, the President of the Supreme Court at this point, observed during the hearing, a judgment which results from an unfair trial is written in water. An appellate court cannot seize even on parts of it and erect legal conclusions upon them. That is why, whatever its precise meaning, it is so hard to understand the Court of Appeal's unexplained order in this case that all issues of liability had in one way or another been concluded. Had the Court of Appeal first addressed the issue of whether the trial had been unfair, it would have been more likely to recognise that the only proper order was for a retrial. And then at the end of that paragraph, his lordship says, conscious of how the justice system has failed both sides, this court with deep regret must order a full retrial. And I say in this case, there must also be a rehearing.
Could you explain to me, please, Mr. Cumming, why, assuming everything you say is right, this was an, contrary to natural justice, the respondents behaved woefully, all the orders should be set aside, why it is in the interests of the beneficiaries of the trust and charity for there to be a rehearing of all the issues in this case before a Supreme Court judge, rather than this court making the appropriate orders that it thinks should be made in the circumstances?
Absolutely, my lady. And the answers are, well, the first point in response is this court does not have all the material it needs in order to draw that conclusion.
What does it need?
We saw When it needs fuller submissions, it needs fuller submissions and proper submissions on all of the points that I was tackling yesterday. We saw that many of those points need factual investigation. They concern Mr. Brockman's intention in executing the 1993 DORA. They concern the capitalisation of Grosvenor Trust Company.
Why is there any of that of relevance given where we've got to?
Well, it's irrelevant because the right approach, the right conclusion needs to be reached for the proper administration of the trust in the future. What if the 1993
why isn't that a matter for a new independent trustee to consider? Let's assume that all the previous trustees behaved badly or well, there was a lack of natural justice in the courts below. We've got to consider what going forward is in the best interest of the beneficiaries, haven't we?
Indeed, my lady. And what is in the best interest of the beneficiaries is a proper conclusion on all of these matters. To answer the beginning of the question, why can't a new trustee do all of this? Because it will be bound by these orders, in respect of which an appeal will have been, I don't know what order might be made.
Right, we've had your arguments on that point. Thank you very much.
I'm grateful.
And if I might add to what my lady has observed, as regards what we might need to make a determination in this respect, what else do we need apart from what evidence there is that shows an irreconcilable conflict of interest on the part of SJTC?
Well, we're talking there, my lord, about removal of SJTC if the orders would otherwise be set aside. What we need is, in relation to that, and I hadn't given a complete answer in respect to that a moment ago, what we need is evidence. Firstly, what we need is to identify just what it is that's said to merit SJTC not being trustee. If it appears that it is simply...
In a very wide sense, I described it as an irreconcilable conflict of interest, but there are a number, I think 3 or 4 clear indicia in that regard, one of which is the position of Mr. Tameen as the sole shareholder of Cabrita, which can change the directorship of SJTC itself. You speak of an undertaking given by him, but why should this court be satisfied as appropriate for this trust to be allowed to continue under the yoke of such a situation? That is just one of the 3 or 4 matters which I have already addressed, which point to an irreconcilable conflict of interest.
Well, I have to challenge then respectfully the conclusion that there is an irreconcilable conflict of interest. I don't accept, for the reasons I've touched on, that there isn't a conflict of interest. I don't accept there is any evidence, and indeed it is not alleged, that Mr. Watlington and Mr. Ferguson would do anything to jeopardise the rights and interests the trust might have in relation to what might be described as a conflict of interest. Moreover, if Mr. Tameen gives his undertaking, or if it's accepted, there's no prospect of Mr. Tameen causing any problem whatsoever, in circumstances where all concerned were very happy for the apparent, the putative conflict of interest to subsist for well over a year.
In that regard, why should the trust be put in the position of having to abide such an arrangement involving Mr. Tameen, who is clearly in a position, inimical to the position of the trust, as somebody who has been granted immunity in relation to the testimony he might provide against not just Mr. Brockman, but the trust itself?
Well, I'm not sure that I understand what the potential consequence of Mr. Tameen's immunity is said to be, my lord, in order to answer that question.
Well, I don't need for me to tell you what they are. It's rather the other way around.
Well, the other part of my answer, my lord, was going to be that it's to start in the wrong place to say, why should SJTC be trustee of this trust? It was the trustee of this trust. The court's process was abused to replace it with a vehicle under the sole control of Mr. Gilbert, who is implicated as snapper in the US indictment. That was wrong. That should not, in my respectful submission, be allowed to stand. So the question then is, what proper basis, and this is, I think, how your questions began, my lord, what proper basis is there to, the question then becomes, what proper basis is there to remove SJTC as trustee? Well, Mr. Tameen is its shareholder. Yes, that's true. But the only risk of that is said to be he might somehow interfere with the Tameen proceedings. Well, he contends that the Tameen proceedings are simply, effectively, harassment pursued by Mr. Brockman. I don't take a stance on that. But that is a question that ought to be properly judicially determined with argument from both sides before it's assumed that there's a proper situation of disharmony that somehow is going to stop the trust being properly administered. And we looked at the authorities earlier, which showed that mere disaffection, mere disharmony itself is not a proper ground for the court to remove a trustee. So that's why I say it's important to know just what the case is against SJTC. I think it is only that point, well, Mr. Tameen's the shareholder and there are proceedings against Mr. Tameen. Well, those aren't proceedings overwhelmingly that are trust proceedings. They're the proceedings of a subsidiary company, which if SJTC was allowed pro tem to be trustee, as it ought to have been, won't be jeopardized because it's undertaking not to take steps outside the ordinary administration of the trust. So it's not going to be influencing the directors of Spanish Steps, which has the claims. There's no suggestion Mr. Watlington and Mr. Ferguson will do anything to prejudice the trust's interest in respect of those claims, quite properly. The risk is only said to be, well, Mr. Tameen might come in and replace them. It's not put this way, but with some crony who can't be trusted in the way Mr. Watlington and Mr. Ferguson can. But that's off the table because he said he won't do that without a court order. And respectfully, I do think it behoves the court to be precise about just what the problem is. What is the risk that the trust will not be properly executed? And I say this not because I'm desperate for SJTC to be a long-term solution to this, but just because what's said is the reason these orders must stand with a whole panoply of relief is because, well, it would be bad if SJTC was the trustee. Well, I respectfully don't accept that premise. It's not ideal. Far from it. That may well be an understatement in respect to Mr. Tameen's shareholding. But what better option is there? A party that has effectively, through Mr. Gilbert, its guiding mind, sole member and sole director, abused the court's processes in order to get appointed. A third party that's emerged, as I say, in circumstances that appear carefully choreographed shortly before this hearing, where, in my respectful submission again, this court cannot properly scrutinise that appointment, where court blessing to that, it's not even blessing, where the court appointment of that fiduciary is sought. And I add again, because this is a bit shrouded in the midst of my other submissions, if the orders are allowed to stand, Mr. Lang will be endorsed by the court as protector, without, again, in my submission, proper scrutiny over that having taken place. That's not, in my respectful submission, in the best interest of the trust. It may very well be that the least worst option is a suitably restrained SJTC with the undertakings that can hold the ring pending a hearing to take place at first instance, hopefully in pretty short order, where this proper scrutiny can take place. And I would ask, hypothetically, what is the problem with that? All it can realistically, in my respectful submission, be said to be is, well, there might be a hold-up in funds for charitable giving. But there's very little evidence before the court of that. There's no detail whatsoever. And there are other funds available to the trust. I've talked about the millions that are held in the Butterfield account in Bermuda in the name of SJTC at the moment. So I really do ask genuinely, and what actually, in real terms, aside from rhetoric, is the practical difficulty said to be with reverting to the position that should have subsisted but for this abusive process and this breach of natural justice. I don't know whether I can assist your lordship and your ladyships more on that point at this stage, or whether it's most convenient for me to just move on to my next point. I shall move on. The second ground of appeal is that both the orders were obtained in abuse of process through the failure to provide full and frank disclosure and through the abuse of the Chief Justice's order. At both hearings, there was no full and frank disclosure, including as the lack of authority of Mr. Gilbert and of Conyers, and a misleading picture was presented to the court at both hearings. And at the December hearing, the issue was what was said and what was not said about the interim injunction to Mrs. Justice Sue Williams. And the issue was the way in which that hearing was a collateral attack inappropriately on the corporate proceedings themselves. As I've said, full and frank disclosure is, I understand it, common ground. The appellant, SJTC, because it was not before the court, was not able to give full and frank disclosure as was demanded of the trustee. And so that, in my respectful submission, is dispositive of this ground of appeal alone. It's particularly the case where Mr. Watlington and Mr. Ferguson didn't know of either hearings. And in respect of the December hearing, that was part of a deliberate strategy. Mr. Gilbert at the December hearing was labouring under an actual conflict of interest because of his interest in Medlands. And Conyers at the December hearing was also acting under an actual conflict of interest, to the extent it was wrongly purporting to take steps in the name of SJTC, where it was intending to act also as attorney to Medlands thereafter. And all of that is striking in light, particularly in light of what we've subsequently discovered. Beyond that, there were repeated submissions that led to the December order in particular that were either inaccurate or at the very least were made other than in accordance with the obligation to present matters fairly or to discharge the duty of full and frank disclosure. They include the absence of any explanation, still less a proper explanation, that Mr. Gilbert and Conyers were not properly authorised to act in the name of SJTC. It appears no reference at all was made to bylaw 4.1. The absence of any explanation, still less a proper explanation, of the basis on which the Chief Justice had made the interim injunction, as I addressed earlier in the day. It was said to hold the ring. He'd said that it could be used to carry on business as per normal, in accordance with Mr. Adamson's submissions in his judgment. The absence of any explanation, still less any proper explanation, of the failure to inform the Chief Justice about the admin proceedings. This is an explanation to Mrs. Justice Sue Williams about that, or about the intention to appoint Medlands as trustee. The false representation at the hearing that led to the November order that matters were properly agreed by all relevant parties, which led to Mrs. Justice Sue Williams saying she'd signed the order on the basis it was an agreed position, failed to take account of the recently appointed Mr. Watlington and Mr. Ferguson, who'd never seen the order, still less agreed to it, and Mr. Gilbert's inability to present matters to the court at that stage, acting unilaterally in the name of SJTC. Again, at the December hearing, the December order was stated to be in a form everyone had seen and agreed to. It overlooked SJTC, had never even seen it, didn't even know the proceedings were happening. There was no scrutiny, certainly no proper scrutiny of the wide-ranging relief that was sought. There was a failure to draw properly to the attention of the court the ongoing investigation of the Department of Justice in the US and the related absence of any question as to the nature of Mr. Gilbert's relationship with Mr. Brockman. And I repeat again that Mr. Gilbert's not denied being Snapper, who's referred to as Mr. Brockman's secret communicant in the indictment. There's the inaccurate characterization at the December hearing of the appointment of Mr. Watlington and Mr. Ferguson as being an attack. And I won't burden your lordship or your ladyships by asking you to turn it up, but for your note, that's apparent from bundle 5, tab 53, page 3396. And the attack was supposed to be, I quote, to prevent the litigation against Mr. Tameen as part of a desperate attempt by Mr. Tameen to prevent scrutiny over his misdeeds. That's volume 5, tab 53, page 3400. And this feeds into the point that I was addressing at the end of my submissions on the first ground. This is what was said to justify the SJTC not being trustee. That Mr. Tammy had appointed Mr. Watlington and Mr. Ferguson to prevent the litigation against him, and it was part of a desperate attempt by him to prevent scrutiny over his misdeeds. Well, not only does that assume the answer to an important question on misdeeds, but the Chief Justice has already found in the corporate proceedings that that wasn't the case. And indeed, no allegation now is persisted with against Mr. Watlington and Mr. Ferguson, and that's right, nor should it be. And so again, it would be very unfortunate if the position of Medlands, Mr. Lang and Mrs. Brockman was allowed to drift through based on some ill-defined innuendo about SJTC in circumstances where it's difficult to identify real prejudice that ought to prevent a proper first instance hearing taking place. There's also an inaccurate suggestion in the transcript that led to the December order that it was the appellant's, quote, hope in the corporate proceedings that the Chief Justice would hold that Mr. Watlington and Mr. Ferguson were never appointed. The reference to that is Bundle 5, tab 53, page 3412. That was not the position of SJTC on any proper view. Further, at the December hearing, a lengthy and misleading analysis was provided of the alleged remuneration arrangements of Mr. Watlington to support a submission that the amount of remuneration was, quote, actively concealed, unquote, by Mr. Watlington. And for your notes, the reference there is Bundle 5, tab 53, pages 3414 to 3417. And also Mr. Gilbert's 7th affidavit in the trust proceedings at paragraphs 91 to 94, Bundle 5, tab 46, page 3284. It was said to Mrs. Justice Sue Bear-Williams that Mr. Watlington had actively concealed his remuneration by adding redactions over documents that had been provided. And it was suggested that this was all because of some nefarious intent. And it was the smoking gun, in effect, these weren't the words, but the smoking gun that Mr. Watlington was a rotter. Mr. Watlington had never been asked at the time of the December hearing about any of this. As soon as he was asked, he explained the very mundane situation around it, and the allegation was never persisted with entirely properly. But this was used at that hearing as, at that stage, the excuse to suggest that SJTC ought to be nudged aside so that the party favoured at that stage by Miller and Chevalier could be and should be appointed. And again, finally, in this regard, at the hearing that led to the December order, it was said the appellant's position was that it was expedient under Section 31 of the Trustee Act 1975 for Medlands to be appointed trustee, when again, that was not SJTC's submission, nor could it or should it have been, given Mr. Gilbert's control, complete control over Medlands. It is inconceivable, if SJTC had been properly before the court, that it would have made anything close to those submissions, or that it would have allowed any submissions to those effect to go unchallenged. That's a breach of the duties of full and frank disclosure that pertain. And they're particularly serious given the circumstances of that hearing. If I could ask you to go to Bundle 5 on this occasion. Bundle 5, tab 53, it's the transcript of the December hearing. At page 3391. It's probably best, I'm sorry to do this again, probably best to pick it up at 3390. The penultimate submission or statement towards the bottom of the page, the judge, can we keep it to 45 minutes? Mr. Elkinson, well, my lady, can we make the head start and see where we are in that time? Because I think a lot of it is, my lady would have seen the skeleton argument. The authorities emphasise what's in the skeleton and some general principles. The judge says, let me just correct you there. I've not read into anything that you filed. So don't assume that I've seen anything. I don't want you to operate on that assumption at all. And I would invite the court to look at this transcript in full, insofar as it hasn't already been read, in which case it oughtn't to be a matter of concern. And also the transcript of the November hearing, such as it is, behind tab 44. So bundle 5, tab 44, page 3217 it begins, to see just how thin what actually took place on these occasions was, apart from some mud being flung against Mr. Watlington, Mr. Ferguson and Mr. Tammy. The consequence of a breach of the duty of full and frank disclosure is that the orders should be set aside, even on this ground alone, particularly given there is at least a very real prospect that different orders would be made. And again, I'm picking up a theme of points that I made at the end of my submissions on ground 1. But the test on appeal is not whether the breaches of natural justice resulted in a conclusion that is actually in the best, that the Court of Appeal thinks is in the best interests of the beneficiaries. Because that conclusion cannot, in my submission, properly be drawn until a proper hearing's taken place, with issues properly identified as required by law and practice, with proper evidence before the court that all the parties want to adduce, and proper argument having taken place. But above and beyond the full and frank disclosure issues is the point that the December order itself represented an abuse of process. It was a collateral attack on the corporate proceedings. It led to the Chief Justice, as you'll have seen from his judgment, deciding that, this is his March 2020 judgment, deciding that the corporate proceedings had been rendered an academic exercise. And that attempt to try and outflank the corporate proceedings by getting Medlands appointed, such that, for practical purposes, because SJTC had been rendered an empty vessel, as the Chief Justice also put it, did it really matter if Mr. Watlington and Mr. Ferguson were directors or not, was an abuse. And that is apparent from the suggestions that were made to Mrs. Justice Sue Bear-Williams that there was no need to notify the parties to the corporate proceedings of the December hearing. You see that recited in paragraph 6 of the recitals to the December order. And that extraordinary relief that was designed to try to shut SJTC out of ever finding out what had taken place. The relief in respect of the lawyers, the relief in respect of the advice, the relief bizarrely removing it as a party, the relief precluding it having access to the court file to even find out what had purportedly, but not, been done in its name. And I'm sorry, I will go back to the Chief Justice's decisions once more. His December judgment, bundle 3, authorities bundle 3, tab 90, page 1964, paragraph 45. So authorities volume 3, tab 90, page 1964, paragraph 45. The Chief Justice concluded that despite the fact that paragraph 36, and that's of the December order we're concerned with here, allowed Medlands to provide a copy of the redacted order to the court in the injunction proceedings, the copy wasn't provided until after the inter-parties hearing in February 2020. A copy of the order was in fact provided by Mr. Gilbert in the redacted form on the 15th of April, and I've covered that. The court accepts Mr. Brownbill's submission that the unusual terms of the redacted order appear to be specifically designed to deny SJTC, the new directors and Cabarita, any means of finding out what Mr. Gilbert had done to secure the redacted order or the basis on which the order was obtained. Then turning back to bundle 5 to see what was said at the December hearing in this regard. Bundle 5, tab 53, page 3433, 3433. The judge says, now, sorry, I'm not on the right page myself. The judge says on page 3433, St. John will no longer be permitted to access the court file without permission. Sorry, that's Mr. Elkinson. St. John's will no longer be permitted to access the court file without permission of the court. And for obvious reasons, my lady, in the event we fail with the injunction, St John's would then be in the hands of directors, and they shouldn't be able to see these without my lady's permission. Maybe my lady will grant. Then the judge says, well, no doubt they'll make an application. Mr. Robinson says, indeed, oh, indeed. There's been the ridiculous battle that has taken place that I've already touched on to try and get those documents. And the only conclusion to be drawn from this is that the strategy, and I've taken your lordships to the letter that makes this clear, the strategy was not to tell intentionally the directors, to keep them in the dark and hope that they may never find out. My third from final authority is in Joint Authorities Volume 2, at tab 42. It's the decision of Lord Diplock in the well-known case of Hunter and Chief Constable of West Midlands Police. And the page reference for current purposes is 842. My lords, this is a case about abuse of process of the High Court. It concerns the inherent power which any court of justice must possess to prevent misuse of its procedure in a way which, although not inconsistent with the literal application of its procedural rules, would nevertheless be manifestly unfair to a party to litigation before it, or would otherwise bring the administration of justice into disrepute among right-thinking people. The circumstances in which abuse of process can arise are very varied. Those which give rise to the instant appeal must surely be unique. It would, in my view, be most unwise if this House, then the House of Lords in England, were to use this occasion to say anything that might be taken as limiting to fixed categories the kinds of circumstances in which the court has a duty, I disavow the word discretion, to exercise this salutary power. I say such a duty applies in this case. And it is irrelevant that one of the beneficiaries representing 2 or 3 of the other human beneficiaries says, oh, well, we don't consider this is in the best interest of the beneficiaries. It may well be, and we saw yesterday the potential tax consequences that have been uninvestigated of the transactions that were effectively affected by the November order and the December order. It may very well be that those substantially affect in the future the interests of beneficiaries, and the charities are interested in this because they affect the assets of the trust or the exposure of other beneficiaries to the incidence of taxation. That's just one example. And that is precisely why a proper scrutiny of this ought to take place. My final ground, which I can take quite quickly, and I'm in your lordship and your ladyship's hands as to whether it would be convenient for me to take it now. There's 2 authorities I need to go to in relation to it, or whether it's best for me to briefly conclude it after the adjournment.
Will you be able to conclude in 8 minutes?
I think it might be just a tad beyond 8 minutes, my lord. I wouldn't want to commit to that.
Very well. Unless there are any objections, shall we take the luncheon break now? Yes.
No objection from me.
Right, thank you. So for 45 minutes, and then Mr. Cummins will wrap up in 10 minutes or so when you return.
I'm grateful, my lord.
Thank you.
We're going to the breakout room.
Yes.
To the breakout room.
We are resumed.
Yes, I believe we're about to hear from Mr. Cummings again. Mr. Cummings, I'd just like to remind you that you indicated to us that you would take approximately 10 minutes. It's become vitally important that you not extend your submissions beyond that, as we are now expecting to hear from an additional party who had not appeared prior to this time.
That is the Attorney General.
That is the Attorney General.
I understand, my lady, and I hope I will be much less than 10 minutes. The third ground of appeal is that it was inappropriate to grant all the relief other than Bedo relief in these proceedings. This is because at the same time as purporting to authorize corporate proceedings, with a view to the issue arising in those proceedings being separately determined, at recital 3 to the December order, Mrs. Justice Subare Williams also recorded the conclusion that the appellant was not a proper and appropriate candidate for appointment as trustee, for reasons including, expressly, quote, in light of the issues arising in, unquote, the corporate proceedings. Well, that, together with the other relief consequential on that finding, effectively determined the central issue in the corporate proceedings at the same time as the judge was granting Bedo relief in respect of those proceedings. That's what led the Chief Justice to observe at paragraph 238 of his December 2020 judgment. The reference to this is Authorities Bundle 3, tab 90, page 2048. I quote now, the commercial effect achieved by the order of the 19th of December 2019 was to render the injunction proceedings and the proceedings challenging the appointments of Mr. Watlington and Mr. Ferguson as directors irrelevant and academic. My submission is that providing all of that relief cannot have been right. I'd like to take the court to two materials in support of that. The first is in Joint Authorities Volume 3 at tab 111, 111, page 2404. Joint Authorities Volume 3, tab 111, page 2404. It's Lewin on trusts from paragraph 48-133. I quote, the Bedo application must be made in separate proceedings. That is not a matter of form, but of substance. The Bedo application is concerned with a question that directly affects the beneficiaries, namely whether trust money should be spent or placed at risk in the main action. Accordingly, beneficiaries are necessary parties to the Bedo application since they're entitled to be heard on that issue. That question involves a review of the merits in the main action from the viewpoint of the trust, not of the other party. Then there's a typo, it seems. Not only should the Bedo application and the main action be separate proceedings, but also the judge dealing with the Bedo application should be different from the judge dealing with the main action. In the interest of time, I won't take you to it, but the case of Alsop Wilkinson against Neary is in Joint Authorities Volume 1 at tab 15, and at paragraph 257, it is made clear in unambiguous terms that the judge who deals with the Bedo application must be different from the judge dealing with the main action. This point's expanded on in my skeleton argument, but I don't propose to circumnavigate that anymore.
If I might hear, what would you regard as the main action here?
Well, the main action here was the corporate proceedings.
Was
the corporate proceedings in respect of which...
right. Well, Justice Subare Williams wasn't the judge in the corporate proceedings, was she?
No, she wasn't, but she effectively determined those corporate proceedings, as the Chief Justice recognised in paragraph 238 of his December judgment. The point is one of substance rather than form. A judge who is determining the issues that arise in the proceedings in respect of which Bedo relief is sought ought not also to determine those issues. So my submission, it matters not that technically it might be there were other proceedings on foot which, in the Chief Justice's words, were thereafter irrelevant and academic. So I simply say, to the extent any matters of substance involving the administration of the Brockman Trust did arise for determination, the persons who are appearing before the court in December should have sought to have them considered and determined by a judge other than Mrs. Justice Subare Williams in separate proceedings. Subject to two final points, one of which has already been addressed, which was that the Attorney General wanted to be heard. I had a message to that effect during the adjournment. I wanted to make one final point that arises from the relief sought by Mr. Machel, Mr. Ham and Mr. Tregear. In the event that the court may be minded, contrary to my submissions, to contemplate appointing BCT Limited. It is striking that the relief they seek is to have the matter remitted to first instance to decide, as I understand it, when the appointment should take effect and the terms on which it should take effect. If that's to happen, in my submission, the appropriate course would be for the whole question of appointment also to go. The Court of Appeal can give whatever indications it considers appropriate in so doing, if it considers any indication is appropriate. And the questions that I've addressed in my submissions, including questions for Mr. Lang, including questions from Mrs. Brockman, and including questions about the administration of the trust, can be dealt with on that same occasion. Unless I can assist further, those are my submissions, and I'll hand over to the Attorney General.
Thank you, Mr. Cumming.
Thank you. Should we be hearing from the attorney now, or should we not be hearing from Mr. Brownbill?
I think it should be, is it the first responder?
Sorry, my lord, my ladies, is it the intention to have the Attorney General's chambers go next or after the first respondent?
We were expecting the first respondent. I don't see that he's present.
My lady, I think what I had been envisaging was that Mr. leaving aside the question about the attorney, about which I knew nothing till a minute or two ago, was expecting Mr. Brownbill to go next, because he is, so to speak, on the same side as Mr. Cumming.
Right.
That was my understanding. So,
He does not appear to be present.
Mr. Brownbill, just to be clear, you speak on behalf of?
Mr. Tameen.
Oh,
Yes.
you.
Yes, it does seem appropriate that you should go next, I think.
Yes. I'm obliged, my lord. If it pleases the court, throughout every stage in these and the various other proceedings in this matter, there has been a deliberate and almost exclusive focus on my client, Mr. Everett Tameen. And that focus has principally concerned what we say are grossly unfair allegations of dishonesty in relation to the 3 payments that were made to him out of this structure, the Brockman Trust structure. Now, those allegations for over 2.25 years have only ever remained allegations. And on the back of those allegations, Mr. Gilbert, Medlands and its new management, Mr. Lang, and now even Mrs. Brockman build an entire case. Even yesterday, the court was, if I may say, beguiled by the mere fact of there being allegations against Mr. Tameen. But I aim to show...
In what respect do you say that? I'm afraid I've got to ask you to clarify.
Indeed, my lord. I do believe it was a comment from Lady Justice Gloucester. I don't have it in the transcript, but we can find it, indicating that there were allegations against Mr. Tameen, which meant that he was necessarily conflicted in this matter, and that conflict worked its way down to St. John's.
Well, that must
and I intend to show it.
That must certainly be a legitimate matter for inquiry.
Yes, well, if I may, I would like to try and show that those allegations are grossly unfair, and the mere fact that they've been made does not mean that they should be relied upon for these purposes.
But is it right? Sorry. Is it right that proceedings have been started against your client?
It is indeed correct, yes, my lady.
And I understood it, but please correct me if I'm wrong, that he has in fact agreed to repay the money.
That situation has slightly changed, and I was going to deal with all of that as I progress in my submissions.
So he hasn't agreed to repay the money?
It's a little bit more complicated than that, my lady. All of the funds claimed are fully secured, either in court funds or they are held by solicitors under undertakings to the court in England. So the funds are all ready to be paid. The fact of the matter is that Mr. Tamim did 15 months ago put in a defence to say he was willing to repay everything. But that offer has been met time and time again by the other side, attempting to show or imply that the mere offer to repay is itself an admission of guilt. And that happens on a number of occasions. So given also the fact that no step has been taken in this case, in the Tangara proceedings, as we call it, to progress those proceedings in the year and 3 months since the defence went in. And that includes 12 months since Medlands was appointed. No attempt has been made to progress those proceedings. So they just lie on the file, able for the other side to keep making the allegation that there are the assertion that there are allegations of dishonesty, and as yet they're unresolved. So Mr. Tamim, in a certain sense, can't win here. And
but nothing said by the court would suggest that the court regards them as anything but allegations at this stage, is there?
If I may develop my submissions, my lord, and perhaps the court will then understand the context in which these allegations have been brought and the unfairness of the process that was undertaken below. And most especially the recital that your lordships and ladyships were taken to yesterday, contained in the order following the proceedings on December 19th, 19. These are very serious matters. They are having a direct effect on Mr. Tamim and his life and his family, that these allegations are repeated and repeated and repeated. So I should be greatly obliged if the court could just allow me to develop the context in which these allegations are brought, if I may. Now, if one had read the all of the evidence that was put before the court below, it's quite a substantial amount, and the written and oral submissions before the court in each of the hearings, one can only be left with the impression that aside from a series of historical technical problems relating to the trusteeship of the Brockman Trust going back 20, 30 years, the only issue is to ensure that the Brockman Trust escapes the clutches, as they're called, of Mr. Tamim. Now, it's our submission that of course, that emphasis is far from the truth. The true issue and what this litigation is about involves two elements. What all of this trouble and strife is about is, first of all, the Department of Justice investigation into the tax fraud allegedly committed by Mr. Brockman by virtue of his control of the Brockman Trust, and the strategy adopted by Mr. Brockman to deal with that investigation and now to deal with his indictment. Now, we say that these claims, these allegations, have only been brought as part of that strategy. And they've been brought solely as a result of Mr. Tamim's cooperation in the investigation. They would never have been brought if Mr. Tamim had not decided to assist the Department of Justice in its investigation. Now, if he had continued to work with Mr. Brockman, as he had over the previous 15 years, when all of this happened, he only started with him in 2004, it is inconceivable that those claims would ever have been brought. The same transactions that occurred with as I will demonstrate in a moment, with the approval of Mr. Brockman, they would be on the books. But if Mr. Tamim had continued to work for Mr. Brockman in the way he had before, and he had not agreed to give evidence to the Department of Justice, these claims would never have been brought. And it's a misuse of this jurisdiction's court system that this is allowed to continue in this way. Now, we say that they were brought for the purpose of putting pressure on Mr. Tamim to stop him continuing to assist the Department of Justice and to undermine him as a Department of Justice witness. And all of that is part of a much wider plan to block the progress of the Department of Justice investigation. Now, it's our submission that this is far from fanciful. The court was taken yesterday to the Department of Justice statement that was in the Chief Justice's decision in the corporate proceedings. Now, I wasn't proposing to actually go to that. Your Lordship saw it yesterday. That statement was an extraordinary step for the Department of Justice to take. It is very, very rare for the Department of Justice to intervene in these types of proceedings, to go into overseas proceedings. The proposition that the claims would never have been brought but for Mr. Tamim's cooperation in these proceedings, in the Department of Justice investigation, is readily to be found by understanding, first of all, that Mr. Brockman would never himself have brought or caused these claims to be brought, because he clearly approved these claims, the first two, indeed, in detail. The idea that another beneficiary might have been allowed, and I use the word "been allowed" because of Mr. Brockman's control, but the idea that another beneficiary would have been allowed to bring these claims is equally fanciful. Can the court imagine a situation where Mr. Brockman has authorized these payments? And I understand the rather these references to sham and such like. I can happily address all of that. There are criticisms without any content. But let me just deal with this. Imagine the situation. Mr. Tamim has not given evidence or assistance to the Department of Justice. And one of the other beneficiaries, there aren't that many in this trust, has come along and said, oh, well, look at this. Mr. Tamim has been paid money out of Spanish steps, a lot of money, although a tiny sum compared to the assets, but still nonetheless independently a lot of money. And they say, well, this is wrong because there's no paperwork to support this. There are no dividend resolutions. There are no directors' resolutions of any sort. We should sue him and get it back. Is it realistic that Mr. Brockman would have said, oh yes, carry on, go sue my right-hand man? It's just not realistic in the extreme.
Mr. Brownhill, can I interrupt you to try and cut this short? I understand that for your client that you want to deflect these allegations, But at the end of the day, allegations are being made against Brockman, allegations are being made against Tamim. This court cannot possibly decide where the truth lies or how irresponsible, inappropriate, unfounded those allegations are. And what I don't understand is why either party thinks it's appropriate for the trust of these substantial assets against the background of a DOJ inquiry to be in the hands of a trustee that is controlled in the loose sense or the strong sense by either the Brockman parties or the Tamim parties. And that's where, at the moment, speaking for myself, I don't understand the relevance of all this. What matters is the best interests for the beneficiaries of the trust going forward. And how can their interests be best served by a trusteeship that is a trustee company owned and controlled by somebody against whom allegations are being made on the one hand, or indeed by the Brockman family on the other? Doesn't it cry out for a neutral trustee? And that's my problem with all this. And obviously I've read your skeleton, and please, feel free to develop your points. But okay, let's assume you're right and all the allegations are misguided. We can't decide that.
And I do not expect the court to do so. Our biggest complaint in this situation.
I might add, this is why I was concerned with my rejoinder to you at your suggestion that the court was being beguiled by the allegations. And when I put
so
you
my apologies.
even though they may be simply allegations, isn't the court not obliged to have regard to them for the present purposes?
I accept that, my lord, but the real mischief in this is that when one just refers to allegations, first of all, one ought to be able to give some measure of those allegations and what is behind them. And I accept that this court cannot draw fundamental conclusions. But the difficulty facing Mr. Tamim in this case is that he is being so often attacked on the basis of these allegations, and he has no means of defending himself. Now, I appreciate in the Tangara proceedings that eventually will come to pass, but in all of these other proceedings, he is not. And in the court below, because this is what we're dealing with, the orders below, the order below contains, and I will address the court in more detail on this, but it contains a recital which is highly damaging to Mr. Tamim and anybody who sees the evidence that was put forward before the court. And about the only document, as we know from Mr. Cummings' submissions, the only document that was given any detailed attention was Mr. Gilbert's affidavit, and that affidavit is full of criticism of Mr. Tamim. How is Mr. Tamim supposed to defend himself? I fully accept, could hardly disagree with the proposition that in the ordinary course of events, any trust should be administered in the best interest of its beneficiaries. But this is not the ordinary course of events. This is far from it. The person described as one of the principal beneficiaries, I think by Mrs. Brockman's counsel, if I'm not mistaken, Mr. Brockman is the one who's behind, in our allegation, it's our position, he's behind these attacks. The same beneficiaries can't come back and say we wear two hats and that this trust should be administered solely with regard to us. If they do not want to make good on these allegations, don't make them. They're made in the Tangara proceedings, but how is it right that they should repeat these allegations time and time and time again in all of the proceedings? If they don't want the cost and the trouble, and we all fully accept it will be a very involved process. if this family, these beneficiaries, it's all one group of people, if they don't want the cost of resolving these issues, drop the allegations. If it is correct that this matter can be resolved with a one-line statement that there is in the Tangara proceeding a set of allegations against Mr. Tamim, therefore we can't have a trust involved with him, why do they need page after page after page of criticism of Mr. Tamim? Why do they have to talk about the clutches of Mr. Tamim? If it's as simple as a conflict of interest because there is an allegation, why do we need the rest? And if what we call the Brotman parties, and I know there's some bridling at that, but let's not be too naive about it, please. If the Brotman parties insist on maintaining these allegations, they must face them. If they're willing to drop them, then Mr. Tamim is fine. It's grossly unfair to make the allegations and then say, oh, it's not in the interest of the beneficiaries.
But a new neutral trustee will have to review and consider whether the trust under its trusteeship should be pursuing these claims against Brotman or Tamim or whoever. And that will be an obligation on an independent trustee to consider whether these allegations should be pursued. But fine, but why should the trust money be spent on relitigating all these issues in circumstances where the interests of charity are being reduced, or the financial value of their interests is being reduced by all this litigation about these orders?
A great deal has been said, milady, about all of this litigation. And this is one of Mrs. Brotman's complaints. She says all of this litigation is so expensive and it's interfering with the administration of the trust. But let's be clear, the litigation has been brought by the Brotman parties. If not by Mrs. Brotman, I don't know the extent of her involvement at all. But certainly at the behest of her husband. It cannot possibly be right that Mr. Brotman, through various others, is able to make all of these allegations, not answer them, and then when called upon to answer, says, oh, it's not in the interests of the beneficiaries or the trust to do this. Mrs. Brotman complains about all of the litigation, but every single piece has been brought by the Brotman side. All the litigation began with these proceedings, better relief.
So, Mr. Brown, I don't follow that. When called upon to answer, in what proceeding? Surely those were the proceedings in which the allegations have been raised, not in these proceedings.
They have been, I do apologize, look, they have been raised in these proceedings. They're raised graphically in the skeleton arguments before this court. Do we need to?
Yes, well, there's no need to. As I said, and I think it's clear enough. This court can only regard those as allegations. And their relevance goes to the question of independence. Nothing more than that from our point of view, as my lady Gloucester has made perfectly clear.
Is it not?
But again, they are not for resolution in these proceedings. They are for resolution in Tangara proceedings.
Then then we have to ask, why are they being made? Why are they being made? That all that was needed, if this case is quite as simple as that, all that was needed is for it to be put, the fact of the Tangara proceedings to be put before the court. And to say, well, we can't make any comment on these, we can't say anything about these, but they exist, and therefore Mr. Tamim is disabled. But they don't do that. One has only to read the skeleton arguments to see the attack, the personal attack, going well beyond conflict of interest. The attack being made on my client. It is grossly unfair that this happens. Why do they need to take those steps in these proceedings? That in our submission is the essential issue. Now, if I may just sort of go beyond the position just described, and I appreciate this court cannot make a decision on this, but the evidence is absolutely clear that Mr. Brotman personally authorised the first two payments, and he knew full well that he had. Now, the result of that is that regardless of corporate formalities, whether they were followed or not and what should have happened, it is because of that simply impossible for Mr. Tamim to be said to have received the payments dishonestly. And it's this reference to dishonesty which is the most damaging and hurtful element in this case. It is not an allegation of conflict of interest. It goes well beyond that. It is the whole situation is totally gratuitous. Mr. Brotman certainly authorised these payments. Mr. Tamim did not just turn up one day in September and help himself for no good reason to a couple of random payments, which is the way it is sometimes presented. Lord, can I, and I appreciate you're giving me a lot of leeway, and I'm grateful for it, but it is a most important matter for my client. If I could just give you a reference to some of the material which goes to the truth of what I've just said, just in case there is sufficient time at some point. But in bundle 3, tab 18, pages 1856 to 1862, there are 6 pages of emails in which Mr. Brotman authorises in great detail the first of the 3 payments, the 5.395 payment. And it demonstrates, first of all, the extent of his involvement and control over the trust, and it also his clear approval of that payment. Now, it is said, by way of yet a further criticism of my client, that Mr. Tamim ran this trust as a sham. Now, I confess I don't understand how you run something as a sham. Either it is a sham, and Mr. Langer, because I think the allegation, the assertion came from Mr. Mitchell. If they want to assert that the trust is a sham, let them. I mean, either the trust is or it isn't a sham. You can't run something as a sham. If you run something in an unorthodox manner, if you don't attend upon corporate formality, that's something on its own. That doesn't make anything a sham. The person who does that just takes a risk. But Mr. Tamim didn't run anything. It was run by Mr. Brotman, being no doubt about it. But we must have a look, attend upon the economic effect of all of this and what really matters. Trusts or trusteeship is not an exercise in administrative perfection. It isn't an academic exercise of filling in pieces of paper. Trusts are all about capital sums, which should be protected and invested for the benefit of the beneficiary, of the beneficial class. And what has happened in this case over a 40-year period is the sum of $25,000 has been turned into something in the region of $8, $9, $10 billion. So a sort of po-faced criticism of the approach adopted in this trust, which was undoubtedly unorthodox. For sure it was unorthodox. But if by those unorthodox, indeed eccentric ways, an enormous fortune has been created. And this has got nothing to do with the tax issues. If there's a tax bill to be paid, there will still be an enormous fortune left afterwards. And that fortune has been generated by Mr. Robert Brotman. And he was assisted by a number of people over the years, including in the last number of years by my client. So we will hear no criticism of the manner in which, the informal manner, if necessary, in which everything was done. It has been an enormous success for the beneficiaries. And it is partly for that reason, this allegation that these are dishonest misappropriations is all the more outrageous, because the allegation only arises by virtue of the method being adopted. Now, what is also clear in all of this is it has never been the intention that these claims should actually result in the recovery of money for the trust from Mr. Tamim. As I indicated earlier, Medlands has taken no steps at all to progress these claims in over the years since its appointment. And it had the claims, because the claims in Bermuda are subject to the vesting order, it had the claims vested in it in December 2019. It has done nothing to progress these claims. And it's our submission that the clear intention is to use these claims to cause as much damage as possible to Mr. Tamim. It's almost preferable to Mr. Brotman to maintain the unproven allegations, to enable them to continue to be trotted out with this frequency and ferocity with which they have been in these proceedings. On the courts, taking the approach the court has just indicated, there's absolutely no purpose or need to engage in this ferocity against my client in these proceedings, and they should get on with the Tangara proceedings. The same applies to the delivery up of documents by Mr. Tamim. I won't go into that in any great detail. There is no time, and the point I hope is already made. But here again, Mr. Brotman sat back and allowed these claims to proceed in the knowledge, as the court will have seen from our skeleton, in the knowledge that he had a complete set of the electronic database in Houston and could have provided these documents at any time. Now, one aspect of the delivery up claims, so I do need to address because it'll be raised in response, is that these are what is often referred to refute the interference with the DOJ investigation, is that an agreement was reached towards the end of 2018 for the provision of documents to the DOJ by Mr. Tamim, excluding privileged material. We say that is no example at all of cooperation with the DOJ at all. It's got nothing to do with it. It was agreed when it became apparent that there was no means of stopping Mr. Tamim from disclosing the principal documents. So they turn a necessity into a virtue in this. It is not a valid point. And can I just touch very briefly on the point that arose yesterday when Mr. Cumming was taking the court through the joint opinion. It's the Hagen-Hargreaves Conyers opinion. There was a suggestion in that opinion, and it's typical of the drip of criticism made against Mr. Tamim, that he may not have provided all the material on the constitution of the trust. There is no basis for that suggestion, assertion, allegation, whatever it is, at all. Mr. Tamim has provided all of the relevant material in relation to this trust, and a full copy of his documentary database sits with Mr. Brotman. So if anybody is in doubt whether Mr. Tamim has provided everything, they just go to Mr. Brotman and check. The two can be compared. Nobody has bothered to do that. They much prefer just to make complaints. In all of this, I acknowledge Medlands continues to assert that documents haven't been provided, but they've been doing that for a long time now, and they still haven't taken any steps to enforce what they say is a breach of the rules in England, or the English delivery of orders. So one takes with something of a pinch of salt these constant carping complaints. Now, can I just move on to a slightly different aspect? Of the various people involved in this matter, on what we call the Brockman side, there's Mr. Gilbert, Mr. Lang, Mr. Stainrod, and Miss Bell. Of those, we presently we do not know what they know or what they knew. We've no idea. So we do not say, and we have never said, that they or any of them thought the allegations against Mr. Tamim were false, or more broadly, that they ever appreciated that they were implementing Mr. Brockman's strategy. Now, the new evidence that we're finding rather suggests that Mr. Gilbert actually didn't do any deciding. He was a bit of a cipher. We'll find out in due course. But the striking feature of this case is that the extent to which those concerned are willing to make and repeat these allegations without making any proper inquiry. Mr. Lang and Mr. Gilbert have known since October 2019, following the filing of Mr. Tamim's defence, that it was his case that he received the payments in good faith and that Mr. Brockman authorised those payments. Of course, that's in a defence. It could be true or false. But notwithstanding that defence, that assertion has been made, nobody in this structure has taken the trouble to contact Mr. Robert Brockman and find out from him what the position is. Of course, none of them has ever approached Mr. Tamim to ask for further information, for assistance of any sort, so as to ensure that they are being fair and accurate when putting their names, as each of these has, to these extremely serious allegations. Now, this is, in our submission, all the more extraordinary given Mr. Tamim's detailed evidence in his first affidavit in these proceedings. That was filed in July, and it contains evidence that makes it beyond doubt that Mr. Brockman authorised the payments. Now, in all of this, Mr. Gilbert, in particular, because he is the main, the author of the greater part of all of this material, he has been very cautious about what he says on this and makes some very guarded statements. I don't propose to use time to take the court to this, but if I can just give the references. Paragraph 33 of his sixth affidavit in the corporate proceedings. This is in volume 8, tab 64 at 5379. Mr. Gilbert maintains, quote, "I am not aware whether Mr. Brockman authorised this transfer to Mr. Tamim as he has claimed. He is not aware." And then he says in paragraph 35 at 5380, "I do not know whether Mr. Brockman had authorised it as claimed by Mr. Tamim." Mr. Gilbert has ready access to Mr. Brockman. And insofar as he has not made any inquiries of Mr. Brockman, it's because he chooses or has chosen not to do so. And that, in my submission, suggests that he does not want to ask the key questions of Mr. Brockman because he does not want the answer. If he gets the wrong answer to Mr. Brockman, he's shot his fox. He can't continue to make the allegations. I should say that Mr. Gilbert isn't shy of accusing Mr. Tamim of dishonesty. There are no end of examples of that. It is striking that none of these people ever gave any thought to inquiring before they put their names to this evidential material. And given in the court below that there was a full and frank obligation Mr. Gilbert has come nowhere close to satisfying that obligation in his own evidence. He has not made any attempt to make the appropriate inquiries that one should do when complying with a full and frank obligation. Now, Mr. Lang's position is wholly unsatisfactory in our submission. And this does need, as Mr. Cummings said, proper consideration. And again, trying to take this as quickly as I can, in his affidavit in these proceedings, it's his first affidavit, which is in volume 5, tab 48, starting at 3309, it is not unfair to say that he, in that affidavit, has simply parroted Mr. Gilbert's evidence from his Mr. Gilbert's seventh affidavit. He just simply repeated the same grossly unfair allegations of dishonesty, even though he has no evidence of his own. Mr. Gilbert's affidavit is replete with statements based on Mr. Lang's affidavit is replete with statements based on Mr. Gilbert's evidence. But nonetheless, he's prepared to go along with all of this, and again, without the slightest inquiry of Mr. Tameen or Mr. Brotman. And now we hear yesterday that actually Mr. Lang's first affidavit was in fact prepared by lawyers for Mr. Gilbert. And that must mean lawyers for St. John's Trust Company, or purportedly so at this time. So if that is the case, then we say so much for independence. And independence is the touchstone of the decision that your ladyships are asked to make. The whole essence of this, the new application, as we would call it, is because Mr. Lang and BCT are supposedly independent. But look at Mr. Lang. He is willing to rely on lawyers who owe him no duties whatsoever, who in fact act for a client who is technically adverse to Mr. Lang. Because as protector, Mr. Lang has the power to hire and fire trustees, and therefore he has a policing role in relation to the trustee. So how can it possibly be right that he relies on the trustee's own lawyers without question or inquiry? That alone suggests to us that Mr. Lang is just doing what he's been told to do. And in response to my learned friend, Mr. Machel's submission yesterday, Mr. Lang's views should certainly not be given any significant weight in this matter, at least without much further inquiry. Can I briefly touch on a not unrelated matter, and that is the criticism made of my skeleton on behalf of Mr. Tameen yesterday by Mr. Trujillo, echoed in the letter that the court has seen from Maples FS. As our submissions make clear, we say that the appointment, and this goes to the heart of the questions the court has been asking me, we say the appointment of BCT is a continuation of Mr. Brotman's strategy, both in relation to the investigation and now his prosecution. And we fear that this will result in the continuation of the unwarranted attacks that have been made on Mr. Tameen. Now, we say that it's Mr. Brotman's strategy, no one else's. We do say of the others, Mrs. Brotman, to the extent she's involved, Mr. Lang, and possibly BCT if appointed, will end up assisting him in his strategy in the same way as Mr. Gilbert, Mr. Lang, Mr. Stainrod, etc., have all done as well. Now, we do not say that any of these would be doing this wittingly or unwittingly. We do not know what they believe or what they intend. And we certainly don't suggest a form of conspiracy. That is such an exaggeration built upon the words of the skeleton. There's nothing to imply a conspiracy. And it's completely naive to take these points. Just take the example presently of Conyers, and I apologize to Conyers because their name keeps being mentioned in this matter. But Conyers, we have recently discovered, are instructed or were instructed by Miller and Chevalier. It's interesting because they weren't instructed directly by St. John's or Medlands. They're instructed indirectly by Miller and Chevalier. Now, if Mr. Tamim's position on all of this is correct, we've got Mr. Brockman communicating his wishes regarding his strategy through Miller and Chevalier. As far as, to that extent, that is implemented through Conyers, then we do not say that Conyers are consciously pursuing Mr. Brockman's strategy. They don't know. But the strategy nonetheless is being implemented. Because there are lots of things which are perfectly, on their face, seem perfectly reasonable. And one goes along with them. But it's the strategy behind it is being implemented. And that this is a continuation. This complaint yesterday from my learned friend, Mr. Tugia, is a continuation, the same refrain that we got from Mr. Gilbert. He was forever saying...
Excuse me, just to be clear that I follow the logic of your argument, is it that you're saying that Mr. Brockman's strategy involves these allegations against your client?
Most definitely, my lord, yes.
Yet you say that were he asked, he would confirm that he'd authorize the payments?
Well, I don't know what he would say. He can't say anything.
That's what I understood you to say.
No, I have said several things. One, he did authorize them. We have documentary evidence. Secondly, nobody has bothered to ask him. I say they haven't bothered to ask him in part because nobody wants the answer. Because he may shoot their fox. That's the problem. Now, I don't know what Mr. Brockman will say. I dare say he won't answer. I imagine he will refuse to answer. But if he does answer, it's going to be extremely difficult for him, other than to confirm Mr. Tamim's position. As I say, all of this, the complaint that we had yesterday is a continuation of the same refrain that we got from Mr. Gilbert, that he wasn't doing Mr. Brockman's bidding and so on. But of course, everything that was needed was still done. So the question comes is, how independent-minded will BCT be? Now, we know from Mrs. Brockman's evidence, and we heard about it yesterday, we have this remarkable episode whereby the management of Reynolds and Reynolds has made this remarkable decision that they will pay a substantial dividend only if BCT is appointed. And as was pointed out yesterday, this is as upside down as one could ever get. How can the management of a company, especially one as enormous as Reynolds and Reynolds, be dictating who the shareholders of their company should be? Now, that alone is a cause for concern. But what is deeply troubling is that this observation does not appear to have occurred to BCT or in the officers of BCT. Nobody in this company appears to have said, well, that's odd. How can this happen? Can it possibly be right that the company that we are going to be the prospective owners of will be dictating to us, the owners, as trustees, what should happen. And it is indeed troubling that no questions appear to be asked about this one step. And this is possibly one of the only tests we've got. So this question should be asked of BCT and find out why they thought this was unremarkable, it would appear. If there has been a string of communications, somebody decided not to share them with the court. But if that is acceptable to BCT, then surely we're going to face a repeat of everything else. Any plausibly sensible step that is put before them will be found to be acceptable. And I submit it's not unfair to us to say, all the more so when you've got the uninquiring director. I don't know whether they are uninquiring or not, but the Reynolds and Reynolds dividend decision rather suggests they just might be. Now, regarding, and this will be my last point on this part of my submissions, the court has seen the letter from Maples FS. It's interesting, it's not written by BCT management. It's written by Maples FS. But it would be very helpful to know who wrote this letter, who actually wrote it. Did these words drop from the pen of the prospective BCT directors? Or did somebody else write it? Whose idea was it? Who suggested this letter? What prompted it? It deals with two matters. It deals with the
please
complaints.
remind the reference to that letter.
Yes, let me just, that's going to be, yes, I think that's going to be in volume 9, and I think it's, yes, the letter is in volume 9, tab 89, starting at page 5922. As I say, it would be very helpful to know who wrote this letter, whose idea was it, who suggested it, because there are two elements in it. One is this sort of protestation of innocence concerning my skeleton, which makes no reference in the part complained of at all to Maples. We don't know about Maples or to BCT. But it also addresses the Department of Justice support, if you like, or confirmation that there is no objection to SJTC's directors. But did it come from any of the lawyers, this letter? And precisely what involvement did the directors have? I ask this question, given that independence is the touchstone of their appointment. We have not been shown the communications that have passed between Mrs. Brotman's lawyers and Maples. We don't know what they've been told. And this is Mr. Cummings' complaint about the paucity
Sorry,
of information.
could you just tell me, please, why are you entitled to see those communications, you, Mr. Tameen, who are not even a trustee? Why are you entitled to see them?
Our concern is that on this appeal, this proposal has been raised. In the ordinary course of events, we would not be. I accept that, my lady. But on this appeal, this proposal has been made. And we are concerned to ensure that if there is to be a new trustee, that they are genuinely independent. And for our purpose, and my client's purpose, that is independent of Mr. Brotman. And if it more,
but my lord and my ladies, Mr. Tamim wasn't given permission to intervene in these proceedings for this kind of purpose. He was, he was permitted to intervene in order to object to supposed findings against him.
No, that is simply incorrect. The motive, if one likes, for our intervention was most certainly to complain about the form of the order. And for that purpose, we wanted to have the order set aside. So therefore we joined or applied to join these proceedings and were joined as a respondent, being joined to support the appeal. There are no restrictions on anything that my client were imposed on anything my client could submit on this appeal. We want the order set aside because it contains the offensive paragraph. And therefore we're permitted to make whatever proper submissions any party can make, in my respectful submission. This application, the informal application through Mr. Machel's submissions, his skeleton argument, is completely new, but it is an application that is made in these proceedings. So with the greatest respect, I would respectfully submit that my client is entitled to make submissions. He has a genuine interest in who is going to be the trustee of this trust. He has a genuine interest, a real interest, probably more real than pretty much anybody else, in ensuring, as Lady Gloucester said, that you get an independent trustee who will be obliged to investigate all of this conduct. That would be ideal from Mr. Tamim's perspective. But he is concerned to make sure that this choice is genuinely independent. And we ask these perfectly innocent and reasonable questions to test that independence. If it has become all the more important in the light of what we discovered about Mr. Lang. We now know that Mr. Lang's correspondence was written for him by lawyers for another party. We know his evidence was written for him by lawyers for another party, or at least acting for another party. So why is it not a perfectly fair and reasonable question in this environment where there is a paucity of material that's been put forward? We don't know what has passed between these parties. If they are genuinely independent, why would they be in any way embarrassed by the disclosure of this material? Why can't we be told who wrote this letter? What is its genesis?
My lord, my ladies, I hesitate to interrupt. It's discourteous to Mr. Brownbill. He's asked the question again and again, who wrote this letter? He has tried by innuendo to suggest that this letter has been written by lawyers acting behind the scenes, doing the bidding of Mr. Brockman. If Mr. Brownbill had simply bothered to look at the first 3 lines of the letter, he would see our reference, PEG. He would see a telephone number. He would see an email, petergoddard@Maples. He would then see that in the first of the second of the numbered paragraphs on page 5922, who the directors of BCT are. And one of the directors is Peter Goddard. He will then see that over leaf, the letter refers to allegations which are made in the skeleton argument. And we don't resile from what we said about those allegations, despite what Mr. Brownbill has said. But look, ladies, there is something contrived and faux naif about the approach being taken by Mr. Brownbill in relation to this letter. And I just felt it right to point out that one of the questions he's asked repeatedly as to the writer is answered on its face. Thank you.
I'm not implying anything. I'm asking a question. I'm testing the independence of
the answer is in the...
No, it isn't in there. The actual writing of the letter. The letter could have been drafted by somebody else. I mean, let's not be technical about writing. The letter being drafted by somebody else. If one looks at Mr. Lang's affidavit and his correspondence, it would appear that he wrote it, or persons acting for him. You would have given no indication that it came from lawyers acting for Mr. Gilbert. It is a perfectly fair and reasonable question. If everything is fine, Mr. Tamim may well be delighted if it turns out that there is a clear independence demonstrated by a BCT. That may be the best news ever. It worries us that the selection has been made through the Brockman family. We make no bones about that, because there's always a tendency for a professional to favour the person that's appointed them. But so be it. We make these points. I submit they are perfectly reasonable. And this material, if the court is going to make a decision based on BCT's independence, then it is a perfectly proper question that they're asked to see this material. My Lord, can I just move on? There are just a few points I have left. First of all, comments, submission was made yesterday by, again, Mr. Mitchell on the undertaking that, I hope it was Mr. Mitchell, on the undertaking that was put forward by Mr. Tamim to try to resolve the problem of his involvement as the shareholder of the parent company of St. John's. And the whole point about that proposal was offered, was that it was offered to try to neutralize his involvement as the ultimate shareholder. It was thought to be perfectly adequate, but in the light of the comments, then an adjustment can be made to the undertaking, which I would hope would be satisfactory to everybody. Mr. Tamim has absolutely no desire at all to interfere in the Brockman Trust, and therefore we would offer a slightly varied undertaking. If I can just read this out, I can circulate it afterwards. But it just simply says that for so long as St. John's Trust Company is the trustee of the Brockman Trust, whether de jure or de facto, I, Mr. Brockman, will not personally or through Caparita or otherwise change the board of St. John's Trust Company, PVT Limited. In other words, it's an undertaking equivalent to the kind of injunction that one would obtain in a dispute. This is a complete block on Mr. Tamim making any change whatsoever to the board of St. John's. And I would hope it's received. There may be other objections, that's fine, but the role of Mr. Tamim as a shareholder should be completely neutralized by this undertaking. He says he will not, while the trusteeship of the Brockman Trust rests with St. John's, exercise his powers to change the board of St. John's. Therefore, that neutralizes the notion that the directors are concerned that they could be removed at any time. So I hope that will assist at least the court in their concerns going forward. Any arrangement that is made following this appeal will only be temporary. None of these things is forever. So these are interim measures. Can I just finally make the briefest of submission on Mr. Mitchell's application in his.
Sorry, before you go ahead, my Lord President, before you go ahead, I believe you may have misspoken, where you said, I, Mr.
Yes, I was trying to put it in the first person. It's Mr. Tamim.
Okay.
So it'd be a personal undertaking given by Mr. Tamim. So he says, I will not personally or through Caparita or otherwise change the board of St. John's Trust Company, PVT Limited.
Thank you.
I'm obliged, my lady. Just a very briefest submission, if I may, on the application made by my learned friend, Mr. Machel, through his skeleton argument. And I will not repeat any of the submissions, or do my best not to repeat any of the submissions made by my learned friend, Mr. Cumming. These are just limited to submissions on Section 8.1 of the Court of Appeal Act. This, if your lordships have to hand my speaking note for this, I don't know if it's available to your lordships, ladyships.
Yes.
But I'm obliged. The essence of this, as Mr. Cummings said, is that Section 8 is there for a particular purpose. And that purpose is for determining the appeal that is before the court. That's clear from the wording, in the determination of appeals before it. So the purpose of Section 8 is for determining the instant appeal. And it's our submission that if the appointment of BCT were to go ahead in the manner that's proposed, this court would not be determining the appeal, it would be avoiding it. And that's not the purpose of Section 8. There is a limit to the jurisdiction granted by it, and we submit that that is explained in the authority that we refer to in our speaking notes. And we refer here to Ocean Software and K. Now that isn't in the authorities bundle, but we did append a copy of the authority to our speaking note. And in the speaking note, we've extracted the relevant part of the judgment. And just by way of background, very simply, and simplifying what is a slightly complicated background, in this case, the plaintiff successfully appealed to the Court of Appeal following a refusal of ex parte relief sought at first instance. And he was successful, as I say, before the Court of Appeal, again operating ex parte. After that, and ignoring certain other events, the plaintiff made a further application to the Court of Appeal for additional injunctive relief. In other words, he wanted to expand the scope of the injunction he'd already been granted by the Court of Appeal. Simultaneously, the respondent applied directly again to the Court of Appeal for the full discharge of the entire injunction. The Court of Appeal refused to entertain both applications. And if I could at some point invite the court to look at these, there's about a page and a half of text from Lord Justice Scott's judgment to a judge panel, and Croom Johnson, LJ, agreed with Lord Justice Scott's judgment. And the essence, because it'll take too long to read all of this, but in our submission, the essence of this judgment is absolutely clear. The Court of Appeal considered that the applications before it, in particular the plaintiff's application, went beyond the scope of Section 8. And what the reason for this is essentially that the Court of Appeal in this judgment had decided that under the English equivalent of Section 8, which I accept is slightly differently worded, but in our submission it's a difference of no consequence. The Court of Appeal decided that the English version did not permit original applications under the equivalent in England. It did not permit original applications. And in our submission, the application that is before this court for the appointment of BCT is an original application. It was not before the court below. It's quite the opposite. The court below was being asked to appoint somebody else. Completely different. So the application to appoint PCT goes well beyond, in our submission, section 8.1.
Could I ask you, Mr. Brownhill, on this, please? You would accept, would you, that we're entitled as a statutory court of appeal to make all orders that the court below could have made?
Indeed, my lady, the width of that is extremely broad. Yes.
So if the court below, looking at the matter objectively, had decided that a neutral trustee should be appointed, you would accept, would you, or would you not, that it could make that order?
If the making of that order involved an original application, a new application.
Why does it need an application by any party? That's what I'm not understanding at the moment.
Well, if I understand the matter correctly, this court is entertaining what I understood to be an informal application contained in Mr. Machel's skeleton argument. How else is anybody to address this matter if we don't at least accept that there is an informal application before this court?
No, I don't think you're, with respect, quite answering my question. My question was that if the court below, having heard about all this evidence and allegations going one way and the other, had come to the conclusion that the correct outcome was to have a new neutral trustee, are you saying that the court below could not have made such an order?
Certainly not, lady. The court below could have made such an order, but only if it had the appropriate application before it. So in other words,
why does the court, exercising its trustee jurisdiction, need to have a formal application before it in order to make such an order?
Well, it's pure, the court below, I suppose, could, in very rare circumstances, act of its own motion. But I would submit that the circumstances in which the court acts of its own motion are so rare and so limited. The court in below went through, at least the parties, went through great contortions to ensure that there was an applicant before it for the relief it was seeking. But in this circumstance, for the court of its own motion to do this, that is a jurisdiction which has to be considered in the light of the scope of its powers. The powers that this court is exercising are those given to it under Section 8. That those powers don't come to the court in any other way. One looks to the court below. Yes, it's got an administrative jurisdiction, the inherent jurisdiction to administer a trust, but that comes under Section 8, and it's quite clear that Section 8 is not a freewheeling, unlimited jurisdiction. It isn't simply to say, can the court do it, therefore the Court of Appeal can do it, in my submission. The section is by its own wording limited. It says in relation to an appeal, it is in the determination of appeals before it. Because if it was anything else, it would mean that applications or decisions, orders of this nature could be made, depriving the parties, not just in this instance, but in numerous other instances, of the ability to go to a first instance court. what the court, if the court is minded to take this route, it should send the matter back to first instance so that the parties have the advantage of proper evidence, proper submissions, the ability to appeal that decision should it ever be necessary, and that would be heavily constrained in the circumstances. But to exercise the power now in this court is to deprive the interested parties of the entitlement to a first instance hearing, which is why,
what do
for the
you
most
say
part,
is the proper evidence that this court should have before it that isn't before it?
For example, proper evidence of the full independence of BCT in this matter, from my client's position, full independence from the Brotman family.
Right.
So therefore, one
Thank
would have
you.
expected. Yep.
In that vein, Mr. Brownbill, will you accept then that if this court were satisfied that SJTC doesn't meet the requirements of independence, that if it were to allow the appeal, it could send the matter back to the court below to consider the appointment of another independent trustee, whether that be BCT or anybody else?
That would definitely be within the scope of what the court could order. It could allow the appeal, but require an independent trustee to be appointed. And that would be done on proper terms. Various parties with an interest in that would, one would hope, be given a hearing in such an event. So, might I just move on to my final submissions, if I may. Mr. Tamim's involvement in this appeal is as a result of the recital contained in the December order, and that order is in the public domain. I don't take the court to it. It's been addressed many times. His interest is in having this appeal allowed and the orders below set aside. Then the recital falls. That's his genuine interest in this matter. It's not academic or minor. In our submission, the appeal should be allowed. It should be sent back for a rehearing for the many reasons put forward by my learned friend, Mr. Cumming. And also, if on that rehearing, and indeed, if on the appointment of a new trustee, if submissions, evidence is put forward, which continue the attacks on Mr. Tamim, then he should be given an opportunity to answer those. I did say at the very beginning, if nobody wants these things to be tested, don't raise them. They can't have their cake and eat it. Now, if the court is against us in terms of this appeal, we still have this offensive recital. Now, it's all well and good for my learned friends, for the other respondents to say that actually the recital isn't critical of Mr. Tamim, and it just concerns a question of conflict. But we have to be realistic about this. It comes nowhere near to saying that. And it could easily be read by anybody as being highly critical. And all the evidence in this case is not before this court, but I could point to numerous instances where matters, comments by courts have been seized upon by what we call the Brotman parties to damage Mr. Tamim. And this will be a case in point. The fact of the matter is, this recital serves no purpose whatsoever. It is completely gratuitous. And that suggests it was included for the purpose of damaging Mr. Tamim. There is nothing in the transcript at all which indicates that any consideration was given to this recital. In our submission, it should be no part of the order, and therefore, if, contrary to my principal submissions, the orders are upheld, then they should be done, or affirmed, they should be done on terms whereby this recital is omitted. My lords and my ladies, unless I can assist you any further, those are my submissions.
Thank you, Mr. Brownbill.
Thank you, my lord.
Shall we hear now Mr. Ham?
If your lordship pleases, can I start by picking up a point that your lordship raised with me yesterday about the representation order appointing Mrs. Brockman to represent the other beneficiaries. And the position is, in summary, that these proceedings were originally begun with only the attorney as a defendant. In July, the proceedings, which had begun as purely Bedo proceedings, were expanded to raise all the historical doubts, etc., and other parties were added. And as part of that process, Mr. Brockman was appointed to represent all the human beneficiaries. And you'll find that in the directions order of the 25th of July 2019, which is at tab 40 of volume 5.
Tab 40, volume 5.
And I don't think I need show you it, but it appointed Mr. Brockman as representative of all the so-called human beneficiaries. And that order was replaced then by the order which I've just given you the reference for of the 7th of August last year, where Mrs. Brockman was substituted for Mr. Brockman as representative of all the human beneficiaries. So that was why I said to the court that all the human beneficiaries were represented before the court. And of course, the attorney represents all the charitable beneficiaries. My learned friend, Mr. Cummings, said something to the effect that that had nothing to do with this appeal. It was only a substitution for the purpose of ongoing proceedings in the originating summons. My Lord, we simply don't understand that. I don't think I've ever come across a case where there's been a change of parties of this sort, where it was felt necessary on an appeal to have a separate representation order. It makes no sense at all. So that's that point. Can I make a few general points about the position of Medlands? First of all, it's not right to describe it as had been described as the private trust vehicle of Mr. Gilbert. And of course, as you know, Mr. Gilbert is no longer involved. A question has been raised as to why Medlands is instructing Conyers. You've seen the letter from Conyers, which shows that they understand the difficulties that arise. But the practicality is that in Bermuda, there is not a firm of attorneys not capable of taking on this matter in short order. And it's therefore been thought appropriate that Conyers should continue to be the attorneys of record. But in order to manage the situation, two steps have been taken. First of all, Medlands has retained specialist English trust litigation solicitors, McFarlane's LLP. And secondly, they've instructed me. So there are, in our submission, two essential questions which the court has to consider on this appeal. The first one, and I can put it in a direct way, is what's in it for the appellant, St. John's? And that concern is exacerbated by what we were told this morning about the funding of St. John's, which is requiring it to take loans. We don't know, I think, from whom or what terms, but why is St. John's incurring expenditure which it has to borrow, and why is it exposing itself to potential risks as to costs?
I thought, Mr. Ham, we were informed by Mr. Cumming that the loans came either from Mr. Tameen or from a company with which he was associated.
I'm sorry, I think that's right. I think I've anyway, the question is still what's in it for St. John's, and in my speaking note, referred to the fact that the evidence of Mr. Watlington, sworn in support of the application to extend time for bringing an appeal. Mr. Watlington says nothing at all about the beneficiaries or their interests or compliance with the fiduciary duties to them. And the points that were made in Mr. Watlington's first affidavit, it's 1D11, which I set out in my paragraph 6, were references to the need to investigate the affairs of the company. And Mr. Watlington said the directors were concerned to investigate matters in due compliance with their duties to the company and to assist, so far as possible, consistently with those duties, the US authorities. And then there's a point in paragraph 43 that the effect of the orders would be to strip St. John's of its purpose of acting as trustee of the B Trust and to deprive it of control over substantial assets held on the trusts. And you'll remember that St. John's is effectively a a one trust PTC set up to act as trustee of this trust. And in her evidence, Miss Bell, and I've given you the reference at paragraph 7, pointed out that Mr. Watlington had said nothing about the beneficiaries of the trusts or their interests or compliance with duties owed to them. And Mr. Watlington made a further affidavit in answer to the affidavit in which Ms. Bell made that point, but he didn't feel it necessary to address the point. Now, we are told that the court is told that the interest of St. John's is to see that everything is done in a proper way and to see that the right thing is done. We respectfully don't think that makes very much sense in terms of the position of St. John's, why it's doing this. And it is another cause for concern. Now, if I can, in my speaking note, I ran through the history of the matter, referring to the joint opinion and the recommendation that an application to the court should be made. That was duly done, and my lord, the president, I think, asked Mr. Cumming whether it was accepted that that was an appropriate thing for the trustee to have done, and the answer to that, we respectfully suggest, is plainly yes. In the light of the advice which had been given, any responsible trustee would have been bound to make such an application. And then it proceeded, and I've given you the references to the directions hearing before the judge and the direction she gave for preliminary issues concerning the 1993 DORA and the change of proper law. And a summons was hit for hearing those issues on the 1st of November, was issued on the 21st of October, and I've given you the reference to that also. I wouldn't normally think it necessary to go through these sorts of procedural details, but in view of the suggestions that there are plots, I thought it appropriate to do so here, and just to make clear that these applications had been made before the appointment of the additional directors of St. John's, at a time when Mr. Tameen having resigned, Mr. Gilbert was left as the sole trustee of St. John's. And it's not a position, therefore, like that in the corporate proceedings, where the proceedings were brought by a minority director and were unauthorized.
Sorry, can I just be clear? The applications you're referring to are the applications that were made in the administrative proceedings.
In the administrative proceedings.
Yeah.
And,
yes,
and those you find in perhaps I should turn it up in bundle 5, tab 37.
5G 37, is it?
5G 37.
Yes.
And there was a summons issued on the very day that the joint opinion was signed off. And there various directions of an administrative nature were made. Then declaratory relief was sought as to the identity of the current trustee, the proper law, the protector, the beneficial class, the validity of a whole string of instruments, the recognition or not of the foreign court orders. And then 5, if and to the extent necessary in light of the declaratory relief sought at paragraph 4, all necessary consequential relief, including an order discharging such person or entity other than the plaintiff as may be declared the current trustee, and an order appointing the plaintiff, that's St. John, as the trustee of the B Fund under the 75 Act, and then an order appointing Mr. Lang, relief from liability for the plaintiff, and then an order that the trustees shouldn't be under any obligation to unscramble anything that had been done while the trusteeship was in doubt, a Section 47 order, and then there's the usual prayer for such further directions or other relief to clarity or otherwise as the court sees fit.
So the application was actually to have St. John's appointed.
It was to have St. John's appointed because it wasn't clear. Well, the advice was that it was probably a de facto trustee and a trustee de Santor and had never been validly appointed, though there's scope for argument about that. So looking at the matter in terms of practical trust administration, one of the most important things you need to know is who was in saddle in place as de jure trustee.
Yes, I see. Mr. Ham, I have a question on your speaking note at paragraph 5. It's not quite on this point, but it's the point about appointing BCT as trustee of the trust. And what I'm not understanding is the last sentence there. All further proceedings against former trustees or de facto should be stayed so as to make clear that none of them is to play any part. I'm not understanding where that application is coming from.
I'm sorry, I haven't explained that. If you look at the title to the proceedings, you will see that as well as St. John's, Medlands, the attorney, the two Brockmans and Mr. Tameen, and Mr. Lang, there are a number of trust companies which might conceivably have a part to play as trustee if the order discharging them as trustees was set aside. And all this is intended to indicate is that it really shouldn't be necessary or appropriate for any of those institutions to play any further part in the proceedings before the judge.
But you also refer to Mr. Tameen proceeding.
Yes.
So I'm not kind of getting this. I thought there were proceedings against Mr. Tameen.
Yeah,
These the money.
No, sorry. I'm referring only to these trust administration proceedings.
Oh, I see. So
which on this hypothesis they're going to be sent back for the purpose of the judge sorting out the details of BCT's appointment. But it's not necessary or appropriate, we say, for Mr. Tameen to be there before the court on that occasion, or indeed St. John's. Does that make it? I'm sorry, that is.
Yes, I see. So you're not saying there in relation to what I might call the third party proceedings in the sense of the trustees suing someone else, a third party. You're not suggesting that those proceedings.
I'm not suggesting that those proceedings authorized by various BEDO orders should stop.
Yeah.
What I'm saying is that in these trust proceedings, these parties who have no further interest, no interest because they are, to use the phrase which has been a bit controversial, strangers to the trust, have no part really to play.
Yes, so your submission is that we should make an order appointing BCT as trustee, but the details of the appointment, what are those? Handover, indemnity?
There'll be the usual debate about indemnities and retentions that one always has.
Yeah.
And experience teaches that they can't be sorted out at the drop of a hat.
Yes, I see. Thank you. Thank you.
Mr. Ham, the summons at tab 37 of volume 5, is that to have resulted in the November or the December orders?
It resulted in both.
In both, I see.
So there was a further summons when it was decided that it wasn't appropriate to go ahead with the application to confirm the position of St. John's as trustee, and it was decided instead to go ahead with the appointment, to seek the appointment of Medlands.
Yes, and where is that summons to be found?
That summons is to be found, I think at, let me just, sorry. That is to be found at tab 45. It's the summons of the 10th of December.
See, thank you.
And you'll see if you look at the draft order, which is attached to the summons, page 3243 of the bundle, an order is sought pursuant to section 31 and the inherent jurisdiction that the fourth defendant is discharged as trustee and replaced as trustee by Medlands. And that's the way in which it is dealt with. So it's an application that at that stage, the contenders to be trustee were the fourth defendant and St. John's, and the way it's dealt with is to St. John's is making the application, and it's necessary for the court only to discharge the other contender and appoint Medlands.
Now, what was the status of the directorship of St. John's at the time when this summons of the 10th of December was filed?
The position was that Messrs. Watlington and Ferguson had been appointed, but there was uncertainty as to the validity of their appointment, which wasn't resolved until the Chief Justice's March order. And indeed, there was also suggested uncertainty as to the validity of Mr. Gilbert's appointment, and what uncertainty as to whether his directorship might have lapsed because he had only been appointed till the time of the next AGM. And those points were argued out in front of the Chief Justice too, and he dismissed those, and he held that Mr. Gilbert was validly appointed. The Chief Justice had made his ex parte order, which authorized, if I can authorize Mr. Gilbert to carry on with the business of the trust, of the company, as if he were the sole director. And there is a question then of construction as to the scope of that order. On the face of it, as a matter of ordinary language, we suggest that it authorized Mr. Gilbert to carry on the business of the company, St. John's. And carrying on the business is, of course, the responsibility of the directors under common form articles, including Article 4 in the present case. So just looking at the order, on the face of it,
What's the reference to the order, please?
I'm just lost it, I'm afraid. It's
I've got it, my lady. It's
volume 4, tab 22.
Thank you.
And what it says is paragraph 3, where you start off with the injunctions against Watlington and Ferguson, and then paragraph 3, the plaintiff may continue to conduct its business in the plaintiff, that's St. John's, may continue to conduct its business in accordance with its bylaws, as if Mr. James Gilbert is sole director, without regard to the member's decision dated the 25th of October 2019.
Chief Justice made specific findings in his ruling as to what that authorized. Well, is it your position that those findings relate only to the corporate proceedings, not to these trust administration proceedings?
My main submission is that though the Chief Justice set aside this order, at the time of the December summons and the December hearing, those orders were in force, that order was in force, and on the face of it, gave Mr. Gilbert authority to carry on the business of the company on his own. And the fact that the Chief Justice subsequently set aside the order cannot, in my submission, invalidate things done by Mr. Gilbert in the interim on the basis of this order. Now, I think it said that the order is to be interpreted in the light of observations made by counsel as to carry on business as per usual, and that did not extend to bringing proceedings to transfer the trusteeship. And that was certainly the view that the Chief Justice took. But respectfully, I would question whether he was right about that, for this reason, that the business of this company is to act as trustee of this trust. It had made very properly and appropriately an application to the court for declaratory relief and other directions, and it was part of the business of the company, per usual, to carry through those proceedings. And what can't be right, I would suggest, is that just because Mr. Ferguson and Mr. Watlington and Mr. Ferguson are appointed Mr. Mr. Gilbert's pre-existing authority to carry on the application he properly caused to be made suddenly comes to a halt. And then one finds the position reinforced by this order that the Chief Justice made. So the consequence of all that is that in my submission, St. John's continued to be a party to the proceedings, properly represented by Conyers who'd been retained sometime previously, and properly acting by Mr. Gilbert. And the point that the Chief Justice was concerned about was that he thought his order hadn't authorized Mr. Gilbert to go so far as to, in effect, to do two things. First of all, not to pursue the application in the July summons for the confirmatory appointment of St. John's, and secondly, not to bring the summons of the 10th of December for the appointment of Medlands.
And perhaps that was because, my Lord President, and perhaps that was because he relied upon the submission that was being made to him and the assurance that was given about holding the ring.
Well, holding the ring, a long time ago, I was grilled by a judge in the Queen's Bench Division in England as to what that expression meant, he claiming he'd never heard it before. And the conclusion I derived from that grilling was that it's not a very good idea to use loose metaphors of this sort.
Yes, but certainly those words weren't being used for no reason.
Those words were used,
and not for no reason.
That caused scope for argument. But looking at the terms of the order.
But that argument was resolved by what the Chief Justice ultimately did. Is that not correct?
Well, it was resolved, but it cannot undo what had been done before on the strength of the order in my submission.
Thank you.
So in effect, you are to be understood to be saying that it was resolved by the Chief Justice insofar as he set aside the injunction and
yes, he discharged the injunction, but this order had been in place, and in particular, paragraph 3 of the order conferring the authority on Mr. Gilbert as to conduct business as if he were the sole trustee, sole director, I beg your pardon. And that was his authority at the time.
Mr. Ham, the application originally, as you told us, was made at a time when there was no question about the authority of Mr. Gilbert. So the application was properly before the court.
The application was undoubtedly properly before the court.
And the court therefore had jurisdiction and was required to deal with the application, whoever had authority, whether Conyers were in breach of their warranty of authority, whatever the position, the application was properly before the court.
In the case of the trust proceedings as opposed to the corporate
Yeah,
proceedings.
in the case
There
of
was no question about the proceedings being instituted without authority, except possibly in relation to the summons of the 10th of December. But the original summons, the 22nd of July, clearly made with proper authority. It would only not have been made with due authority if Mr. Gilbert had not been properly constituted as director, but the Chief Justice rejected the arguments that he had never been appointed or had ceased to be a director.
And therefore, the relief that was contemplated in the 10th of December summons is something that could have been asked for in the original summons.
Could have been asked for without any further document.
Yeah. Thank you.
I was going to go on next to deal with the November order, but perhaps before I launch onto that, this would be a convenient point to break.
Yes, it is almost 4 o'clock Bermuda time.
Well, according to my computer, it's 8 o'clock here.
Yes, even more reason to break now, and for my lady Gloucester as well.
My Lord, my lady.
Might I just
But before we break, could I just ask, please, what the position is about the Attorney General, who is now going to play a more active part, and
Well,
what's envisaged, please?
is that
sorry.
is that by way of asking what will be said on behalf of the Attorney General?
Sorry, my lord and my ladies, just to clarify, we're not taking a more active role. The idea being, I'm just clarifying a few points the U.S. Department of Justice has asked me to put before the court. So we're still maintaining a neutral position, just clarifying a few points.
Will you have a speaking note you could let us have overnight, Ms. Bess?
Sorry, I'm actually Shakira Francois, Deputy Solicitor General.
I'm sorry.
No, that's
I'm
fine.
going by
Crown
the-
Counsel Lawrence Sadler-Bass is actually here with me.
I
So-
see. I'm going by the identification on your Zoom tag.
Yes,
Sorry
no
about
problem. Understood, my lord. So yes, I can provide that overnight.
that would be helpful. It would be helpful as well if you might take instructions from Madam Attorney why it is that the court isn't being provided with fuller representations on behalf of charity, having regard to the attorney's position as parents patron. In effect, there's no one else who can speak on behalf of charity in these proceedings.
Noted, my lord.
If you could please make that inquiry.
Will do, my lord. Grateful.
My Lord President, if you don't mind, may I remind counsel on behalf of the court that we should have their, what were we expecting? We were expecting chronology, yes.
Yes.
Now, I know it wasn't all settled. You said it wasn't settled, but perhaps there's some way you can produce it indicating what is not agreed, or at least indicating what is agreed. I think that we should have something.
I understood it had been provided about 20 minutes or so after we started this morning to Mr. Quallo, and it does indicate there's a colour system on it which indicates what's been agreed and what hasn't and such.
Okay. Hasn't reached us, or at least not me.
Well, perhaps
You would have sent it.
I have it. I have it on the email.
I'll arrange for it to be resent. These things are so mysterious. Let's as soon as this is over, we'll resend. So it's beyond doubt. It'll be the identical document sent this morning, to be sure that everybody gets it. Can I just ask Lord President? There is one point which I didn't complete. It's not an additional point of advocacy. It's a point which is important, I think, for my learned friends. They will all want to. They may want to know. I didn't complete the explanation of Mr. Tamim's revised defence. I'd indicated that he was changing his defence very quickly. It's more complicated than this, but very quickly. He is, whereas previously he was willing to repay all three sums, he's now seeking to vary his defence exactly for the reasons I explained earlier, so that he puts in a defence for two of the amounts, the 5.395 and the 5 million, and a small part of the third item, the 16.8, is 1.2 million of that he is going to put in a defence. It's all to do with indemnities. The balance of that, the 15.6, is acknowledged to be repayable. An issue arises as to who that is payable to, and there is an interpleader application for that. But that's the status of all three payments. As I indicated before, the three sums are still fully secured and will remain so. I'm obliged.
For our purposes, though, we take it that the Tangara proceedings will continue.
Indeed, my lord, they will.
Right. Well, thank you all. Shall we have a word with Mr. Coelho in our breakout room?
All right.
Until tomorrow morning at 9 Bermuda time. Is that agreed?
Yes, 9 o'clock is good, my Lord President.
Okay, and that will be 1 o'clock English time, UK time. Thank you. Well, have a good evening.
Thank you, everyone. You can disconnect from the call, please.